ولا يجرمنكم شنآن قوم على ألا تعدلوا اعدلوا هو أقرب للتقوى واتقوا الله واتقوا الله إن الله خبير بما تعملون وعد الله الذين آمنوا وعملوا الصالحات لهم مغفرة وأجر عظيم لهم مغفرة وأجر عظيم صدق الله العظيم. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Yusuf Ramadan. Hopefully, we read and hear the recitation will be grant his blessing. Amin ya rabbal alamin.
Ladies and gentlemen, next agenda, singing the anthem Indonesia Raya, Sang Surya and Mars Universitas Ahmad Dahlan. To all participants and invited guests, please to mute the Zoom meeting to maintain order in the agenda. Thank you.
Indonesia, kelak Universitas Ahmad Dahlan mengemban amanat mulia, siapkan insan cendekiawan, bidang hari pengetahuan, berilmu dan beramal soleh, berperan dalam membangun umat, Quran dan hadis jadi pedoman. Sivitas akademika pengemban tugas bersama, sing-singkan lengan prajurit serta masyarakat siap berani. Karena karyanya kawan ibu kembangkan teknologi, majulah UAD demi nusa bangsa Indonesia sejahtera. Universitas Ahmad Dahlan mengemban amanat mulia, siapkan insan cendekiawan, bidang hari pengetahuan, berilmu dan beramal soleh, berperan dalam membangun umat, Quran dan hadis jadi pedoman. Sivitas akademika pengemban tugas bersama, sing-singkan lengan prajurit serta masyarakat siap berani. Karena karyanya kawan ibu kembangkan teknologi, majulah UAD demi nusa bangsa Indonesia sejahtera.
Ladies and gentlemen, the next agenda is a dance performance. Ladies and gentlemen, on this occasion to amuse our agenda, let's welcome Lehal Dance. Ladies and gentlemen, what a great appearance of Lehal dance to be appreciated.
Ladies and gentlemen, distinguished guests and participants of International Conference, the next agenda we will follow along with the keynote speech, which will be delivered by Vice Minister of Law and Human Rights of Republic of Indonesia. To Professor Dr. Edward Omar Sharif Hiarit SHM Hum, please take your time.
Warahmatullahi wabarakatuh. Good morning. Best wishes for us all. Om Swastiastu, Namo Buddhaya. The Honorable Rector of Universitas Ahmad Dahlan, Dean of Faculty of Law, Universitas Ahmad Dahlan, speakers, and distinguished participants. Firstly, let us all thank the Almighty God for His given us His blessing today, so that we are all gathered here in the first Ahmad Dahlan International Conference on Law and Social Justice. I would like to thank Universitas Ahmad Dahlan for inviting me, and I'm pleased to be here to commence the discussion on the matter of grave importance that is COVID-19, especially the challenges and opportunities we have to face now and in the future from the perspective of Indonesian health quarantine law. Ladies and gentlemen, before we begin the discussion, I would like to remind us of what Bill Gates said during TED Talk 2015. If anything kills over 10 million people in the next few decades, it's most likely to be a highly infectious virus rather than a war. 5 years later, as is fulfilling a prophecy, coronavirus disease 2019 or COVID-19 pandemic broke out, and since then we have been battling an enemy unlike anything we've ever up against. It's been more than a year, and that count increases still. This virus has become one of the deadliest viruses in the history of mankind, and the sheer number of fatalities reaches 4 million lives globally. The horror of the virus is enormously amplified by the emergence of multiple variants of the virus, especially the far more transmissible and lethal Delta variant, which causes the second, third, and even fourth COVID-19 wave in the several countries. The worsening condition of the pandemic devastates every single aspect of our life. Hospital collapse as the death of patients is unstoppable, and bed occupancy rate in some hospitals even exceeds 100%. By mid-July 2021, 1,367 healthcare workers have passed away. Added with the fact that only 5.9% of the population are fully vaccinated, and 15.1% has received at least one dose of vaccine. The socio-economic impacts are also tremendous, as 2.76 million people have lost their employment. Moreover, by the end of 2020, Indonesia became one of the countries undergoing through recession, with the realization of economic growth on minus 2.07%. Officially, there are myriad other effects of the pandemic that we as a nation absolutely need to resolve. Therefore, to combat this impact, the government has been implementing multitude of methods, principally to mitigate and to prevent the spread of COVID-19. Ladies and gentlemen, the government of Indonesia is basing all policy to combat the spread of COVID-19 chiefly on Law Number 6 of 2018 on health quarantine. The law was enacted as a follow-up to the International Health Regulation of 2005, IHR 2005. Indonesia is obliged to prevent and deter the occurrence of public health emergency of international concern as mandated in IHR 2005. It requires Indonesia to increase its capacity and capability in health surveillance and response, as well as health quarantine in the region and at the point of entry. The regulation stipulates the responsibilities of the central government and regional governments' rights and obligations. Public health emergency, health quarantine document, health quarantine resources, health quarantine information, guidance, and supervision investigated by criminal officers. The very first implementation of health quarantine law in relation to COVID-19 on 31 March 2020, when President Joko Widodo signed Presidential Decree number possibility of the spreading of disease or contamination. The provision is further elaborate on Article 59, entailing certain activities are still allowed as long as they are limited physically and socially. Although many question the decision, the President stated that while the matter of public health is certainly essential, the government must not ignore its obligation to the economy of the people as well. Lockdown, or in the health quarantine law is defined as quarantine, implies that the residents are forbidden from ever leaving the quarantine premise, which essentially shut down the economy. Following the presidential decree, the government of Indonesia enacted Government Regulation Number 21 of 2020 on large-scale social restriction to accelerate the handling of COVID-19 pandemic. This regulation, in essential, authorized regional government to carry out large-scale social restriction toward the movement of the individual and goods for a certain province and or regency or city. The large-scale social restriction was then changed to enforcement of restriction on community activity, we call PPKM, based on Minister of Internal Affairs Instruction Number 1 of 2021, since the number of infection was deemed sufficiently controlled. The newly established restriction was only put into effect in 7 provinces of Java and Bali for 2 weeks starting from 11 January 2021, which was then extended one. The regions were selected as their population was densest, most mobile, and contribute the most to the number of active cases in comparison to other regions. This was then changed again to enforcement of micro restriction on community activity as the previous restriction was deemed ineffective. This restriction still covers 7 provinces in Java and Bali, but rely more on community-based restriction. Afterward, despite strict prohibition on the annual 8th of winter mass homecoming, the number of cases started to approximately 12,000 new cases per day, which prompted the government to tighten the restriction for 2 weeks starting from 22 June 2021. However, after 2 weeks, rather than decreasing, the number of active cases extremely spiked, urging the government to impose the emergency restriction on community activity starting from 3 to 20 July 2021. This time, non-essential sector workers are completely prohibited to work at the office. Essential sector workers are allowed to operate at 50% capacity with strict health protocol. Markets providing daily necessities are allowed to open only to 8 p.m. with 50% visitors. Total prohibition on restaurant, dine-in, communal worship activity, public place and tourism spot, and temporary closing of malls and shopping centers, etc. Ladies and gentlemen, at the national level, interministerial regulation entered into force. The minister had prepared the necessary regulation accordingly. On 3 April 2020, Minister of Health issued the Regulation Number 9 of 2020 on guideline on large-scale social restriction for the acceleration of mitigation of COVID-19. The guideline stipulates the requirements and procedure to enforce large-scale social restriction, as well as how the restriction should be specifically implemented. The guideline also add the restriction mentioned in Article 59 of Health Quarantine Law, namely restriction of activity in public place or facility such as supermarket or medical service facility, hotel, etc. Restriction social and cultural activity, restriction on transportation, and other restriction particularly in relation to defense and security, such as a military and police operation. On the matter of vaccination, as Indonesia is racing to achieve herd immunity by meeting its 70% vaccination of its 2,070 billion population, based on Minister of Health Regulation Number 10, Number 18, Number 19 of 2021 on implementation of vaccination to mitigate the COVID-19. The government has completed its 3rd phase of vaccination. The government target 1 million vaccine administered per day, although as of mid-July 2021, the daily average of administrative vaccine over around 50,000 per day. The number is expected to increase to 2 million per day by August 2021. On the matter of state finance, the government provides tax incentive for taxpayers affected by the pandemic in the form of waiving certain income tax, which were given twice by Minister of Finance Regulation number 86 of 2020, as amended by number 110 of 2020, and Minister for Finance Regulation number 9 of 2021, as amendment by number 82 of 2020. Tax facilities were also given to producers of medical goods and services, as well as medical workers, in the form of additional net income reduction, deductibles to gross income, and imposition of income tax of 0%. Lastly, on the matter of education, the government issued joint decision of Minister of Education, Minister of Religious Affairs, Minister of Health, and Minister of Internal Affairs on guidelines on education during COVID-19 pandemic. The guidelines require educational activity to be conducted face-to-face with limitation and strict health protocol, as well as distance learning. Parents or guardians of the student are allowed to opt whether the student take face-to-face learning or distance learning, as they pose their own pros and cons. The obvious benefit of distance learning include physical separation of teachers and students. However, many Indonesians find distance learning very costly. Thus, the difference of socioeconomic status could potentially hamper equal access to education. This became the main reason why the government reopened school in low-risk area with limitation and strict health protocols. Ladies and gentlemen, these are little examples of what the government of Indonesia has been doing and will continue to do to combat COVID-19 as the implementation of health quarantine law. Clearly, it does not necessarily mean that what the government has done is perfect. The challenges remain, and only together can we struggle against it. Now more than ever, we, the central, regional government, and most importantly, the people, have to be united in participating and contributing to prevent and mitigate the spread of the virus. In the end, our combined and continued efforts are the ones that will save our life, which is why I would like to appreciate Universitas Ahmad Dahlan, as such conference enables us to share any information which we could use to improve how we mitigate the pandemic. I hope you all to have a fruitful and successful discussion. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Professor Dr. Edward Omar Sharif Hiyarich SHM for his remarkable speech. Before that, allow us to present of award for Professor Dr. Edward Omar Sharif Hiyarich SHM as a keynote speech. Thank you.
Dear guests, The next event will be the remarks. The first remarks will be delivered from the head of committee, the first Ahmad Dahlan International Conference on Law and Social Justice, to Mr. Muhammad Nur SHMH. Please take your time.
Your Excellency, Professor Edward O.S. Harris, SHMH, Vice Minister of Law and Human Rights of Indonesia, Associate Professor Dr. Mukhlas MT, Rector of Universitas Ahmad Dahlan, Mr. Rusdi Umar, STMT PhD, Vice Rector for Academic Affairs of Universitas Ahmad Dahlan, Mr. Dr. Gatot Sugiharto, SMH, Vice Rector for Student Affairs and Alumni, Universitas Ahmad Dahlan, Professor Dr. Stefan Kos from Bundeswehr University Munich, Professor Dr. Estrella Arroyo, University of Saint Anthony, Professor Dr. Hyung Jun Kim from Kangwon National University, Dr. James Press from Australian National University, Dr. Rohana Abdul Rahman from University Utara Malaysia, Dr. Normasari SHMH, Universitas Ahmad Dahlan, Mr. Rahmat Muhajir Nugroho, SHMH, Dean of Faculty of Law, Universitas Ahmad Dahlan, the Dean of Faculty of Law from Universitas Muhammadiyah Magelang, Universitas Muhammadiyah Sumatera Barat, Universitas Wijaya Kusuma Purwokerto, Universitas Muhammadiyah Kendari, Faculty of Law and Social Science of Universitas Pendidikan Ganesha Singaraja, Bali, Head of Master of Law Study Program, Postgraduate Program, Universitas Muhammadiyah Palembang, who became the host of this international conference, the Dean of all Faculty of Universitas Ahmad Dahlan, Mr. Anton Yudana, PhD, the Head of Research and Community Service Institute from Universitas Ahmad Dahlan, all of the presenters, invited guests, and participants, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Good morning, guten Morgen, magandang umaga, annyeong haseo. On behalf of the organizing committee, it gives me great pleasure in welcoming you to the first Ahmad Dahlan International Conference on Law and Social Justice, IDCOLS 2021, which is held by the Faculty of Law, Universitas Ahmad Dahlan, Yogyakarta, Indonesia. First IDCOLS 2021 is held as a response to various issues that are happening in society globally today. The global COVID-19 pandemic has led human civilization into another vision of the human future. The dynamic to maintain public health urges nearly all states and international organizations to take necessary, proportional, and appropriate measures leading to legal implications. Aside from the recent global COVID-19 pandemic issue, other matters like digitalization, enhancement and disruption of technology, development of artificial intelligence, renewable energy, biodiversity loss, climate change, deforestation, air and water pollution, access to justice, right to education, poverty, religious conflict, and other issues are also require deep concern by us. Those issues in question may establish certain challenges and opportunities to law and social justice. Therefore, at this conference, we invite various cycles, but academicians, scholars, researchers, and practitioners from all over the world to share their thoughts, experience, and research results concerning these recent challenges and opportunities for the law and social justice. We believe that your presence here, bringing together your expertise, vision, knowledge, and experience, will help us consolidate your ideas, thoughts, and overcome the challenges and take the opportunities in the field of law and social justice today, and help us pave the way into the future. Considering the current pandemic situation, which restricts in-person meetings, this conference we held entirely virtual. More than 400 participants joined this conference, including 60 selected papers that will present their ideas. We would like thank you for your participation, and hopefully these papers can give the contribution for the nation and the world in solving various issues, and as I mentioned before. I also take this opportunity to express our gratitude and appreciation to Faculty of Law Universitas Muhammadiyah Magelang, Faculty of Law Universitas Muhammadiyah Sumatera Barat, Faculty of Law Universitas Wijaya Kusuma Purwokerto, Faculty of Law and Social Science of Universitas Pendidikan Ganesha Singaraja Bali, Faculty of Law Universitas Muhammadiyah Kendari, Faculty of Law, Master of Law Study Program, Universitas Muhammadiyah Palembang, who has become co-host on this first EDICOLS 2021. The last, we hope all of you can enjoy this conference, and we look forward to your support to make this conference a success. Thank you very much. Vielen Dank. Maraming salamat. Kamsahamnida. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Muhammad Nur SHMH for the word. The next speech will be delivered by the Dean of Faculty of Law, Universitas Ahmad Dahlan, to Mr. Rahmat Muhajir Nugroho SHMH. Please take your time.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Thank you very much to all of you for being here today in this virtual room. It is an honor for me to present at this extraordinary event. Before we begin, allow me to express my appreciation to attend this present on this international conference agenda. The Honorable Professor Dr. Edward Masarif PhD, Vice Minister of Law and Human Rights of Indonesia, as a keynote speaker. The Honorable Dr. Muklas MT, as a Rector Universitas Ahmad Dahlan Indonesia. The Honorable Mr. Rusdi Umar PhD, Vice Rector. The Honorable Dr. Gatot Sugiharto, Vice Rector. The Honorable Professor Dr. Stephen Voss from Bundeswehr University Munich, Germany. Thank you, Prof. The Honorable Professor Dr. Hyung Jun Kim from Kwangwon National University, Republic of Korea. Terima kasih, Prof. Kim. The Honorable, my friend, Dr. James Price from Australian National University, Australia. The Honorable Professor Dr. Estrella Arroyo from University of San Antonio, Philippines. Hello, Ma'am Arroyo. The Honorable Dr. Rohana Abdul Rahman from University Utara Malaysia. Terima kasih atas kerjasamanya selama ini. The Honorable Dr. Nurmasari S.I.M. from Universitas Ahmad Dahlan. The Honorable all the deans of co-hosts or partners, the Dean of Universitas Pendidikan Ganesha Singaraja Indonesia, the Dean of Universitas Muhammadiyah Kendari, the Dean of Universitas Muhammadiyah Magelang, the Dean of Universitas Wijaya Kusuma Purwokerto, the Dean of Universitas Muhammadiyah Sumatera Barat, the Head of Magister of Law, Postgraduate Program, Universitas Muhammadiyah Palembang, and all the invitees who attended today. Alhamdulillah Rabbil Alamin. Salatu wassalamu ala asrafil anbiya'i wal mursalin wa ala alihi wa ashabihi ajma'in amma ba'd. Praise and gratitude we pray to Allah Subhanahu wa Ta'ala, who has bestowed His grace on all of us so that we can be here in good health. Salawat and greetings do not forget to convey to the Prophet Muhammad sallallahu alaihi wasallam, a role model for us as Muslims. I'm sorry I haven't been able to perform optimally because I'm currently recovering from being infected with COVID-19. Thank you for all your prayers for me. The global COVID-19 pandemic has led human civilization into another vision of the human future. The dynamic to maintain public health urges nearly all states and international organizations to take necessary, proportional, and appropriate measures leading to legal implication. Subsequently, an obligation of health protocol, enforcement of travel restriction, disruption of global supply and demand chain may also impact social justice access. The recent challenge and opportunities following the pandemic encourage the state of international society to work together, creating a better future for human civilization. The dilemma to keep public health, uphold human rights, ascertain the law enforcement, and ensure access to social justice simultaneously renders a very different level of challenge like never before. Ladies and gentlemen, following the outbreak's impact as an academician, scholar, researchers, and practitioners, it is critical to question how law and social justice will overcome this challenge and seize opportunities to create bright future for humanity. Another interesting question is overcoming challenge and taking advantage of opportunities that affect law and social justice. Given the urgency of the problem and as an academic commitment, Faculty of Law, Universitas Ahmad Dahlan today hold the first Ahmad Dahlan International Conference on Law and Social Justice to be in the media for academic, scholar, researchers, practitioners worldwide to share their ideas in overcoming the global challenge and opportunities issues. Considering the current pandemic situation, which limit to face-to-face meeting, the two-day conference is held entirely virtually. Ladies and gentlemen, hopefully our agenda goes smoothly and we get many benefits. Thanks to all the speakers. Thank you to all partners or co-hosts, and great appreciation for all the committee and parties who support the implementation of this event. I hope this event is useful. Thank you very much for all. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Rahmat Muhajir Nugroho SHMH for his forward.
The audience, we follow along with the final speech and at the same time officially open our agenda today. Dear Chancellor of the Universitas Ahmad Dahlan, Mr. Associate Professor Muhlas MT, please take your time.
Assalamualaikum warahmatullahi wabarakatuh. Good morning everyone. It is my pleasure and privilege to be able to welcome all of you to today's conference, the first Ahmad Dahlan International Conference on Law and Social Justice. On behalf of Ahmad Dahlan University, I would like to thank you for your participation in this conference. First, allow me to acknowledge a number of notable features in this conference. The keynote speaker of today's conference, the Honorable Professor Edward, Vice Minister of Law and Human Rights of Indonesia. Welcome to the conference, and thank you for having made yourself available to share your expert opinion with us today. I noticed we also have a list of invited speakers who are going to share their knowledge and expertise with us today. The Honorable Professor Stephen Koos of Bundeswehr of University Munich, Germany, Professor Estrella Arroyo of St. Antonio University, the Philippines, Professor Hung Jun Kim of Kangwon National University, South Korea, Dr. James Press of Australian National University, Australia, Dr. Rohana Abdul Rahman of University Utara Malaysia, and Dr. Norma Sari of Universitas Ahmad Dahlan, Indonesia. Welcome to the conference. And with us today, we also have Dr. Rusdi Umar, my colleague, Vice Rector of Universitas Ahmad Dahlan for Academic Affairs. My colleague, Dr. Gatot Sugiharto, Vice Rector of Universitas Ahmad Dahlan for Student and Alumni Affairs. Mr. Anton Yudana PhD, Director of Research and Community Services, Universitas Ahmad Dahlan, and also the Dean of Faculty of Law, Universitas Muhammadiyah Magelang, Sumatera Barat, Kendari, and Palembang, as well as the Dean of Faculty of Law, Universitas Wijaya Kusuma Purwokerto, and the Dean of Faculty of Law and Social Science, Universitas Pendidikan Ganesha, Singaraja, Bali. Ladies and gentlemen, of the last 1.5 years, we have witnessed how the pandemic COVID-19 represents one of the most challenging tasks that we have ever encountered. While a great deal of effort has been made to contain the spread of virus as well as to treat those afflicted by the virus, we continue to grapple with a number of problems around the ethical and legal aspect of COVID-19 management. It may have become too familiar to all of us now that enactment of policies and laws in regard to COVID-19 has often become a site of debate in society, inviting different interpretation and understanding. Government policies and exercise of laws to curb the spread of COVID often provoke strong opposition in society. Indeed, enactment of law and policies during the pandemic, such as health protocol, restriction on operating hours of business premises, total lockdown on quarantine, or in the case of Indonesia, large-scale restriction on people activity and movement has often led to public anger on violence. It is argued that the restrictions imposed by the government could put them in danger of no longer being able to sustain their life because of a dramatic loss of income. We have seen a number of examples where different interests come into play to complicate our tasks or dealing with this pandemic. It might still be fresh in our mind how a strict food vendor in Jakarta was fined 5 million rupiah for failing to comply with the protocol of not serving dine-in customers. This is just one of many examples where the exercise of policies and laws at different levels of government, administration, and society involves a web of conflicting interests and at times are very difficult and reconcile. We can see here that there is a question of ethics, social justice, and human rights that need to be addressed in regard to the enactment of any policies and laws designed to contain the spread of COVID. Ladies and gentlemen, the example I have previously mentioned might prompt us to redefine and reshape the way we plan, design, and implement new concept of policies in regard to our effort to overcome the impact of the pandemic COVID-19. In particular, from ethical and legal perspective, we may ask ourselves, what can we do to address the ethical dilemma and legal issues which come along with the enactment of policies and laws pertaining to COVID-19? What sort of mitigation that we can provide to help elevate the burden suffered by society at large from legal perspective and standpoint? Also, what can we do to reconcile different conflicting interests and objectives, respond to the impact of health protocol and different forms of restriction to the pandemic? And we may argue the COVID-19 pandemic has highlighted and enlarged the socio-economic divide between the poor and the wealthy. So, the next question that we may raise is, how can we possibly prevent the widening of such a gap through policy making process? To what extent existing law and law enforcement have been operating in the best interest of social justice? And ladies and gentlemen, we have assembled here today in the hope that we will find a better way of dealing with the complexities of problems that emerge along with our attempt to tackle the adverse impact of the pandemic. I believe we all are concerned with what has been happening around us, both locally and globally, and that's why we are here to demonstrate not only our capacity as academic, but also as agent of change who are strongly committed to helping our government and our society in general to go through this pandemic. I believe this conference will serve as a fruitful space for all of us here, where we can share our analysis of the current situation and come up with a better idea of how to address the ethical and legal dilemma as well as social justice aspect pertaining of the pandemic COVID-19. Before I end my speech, permit me to extend my sincere appreciation to the organizing committee, the Faculty of Law of Universitas Ahmad Dahlan, for your hard work to have made this conference happen. I wish you all a productive and enjoyable conference, and thank you once again for your participation. And I now declare this international conference on legal and social justice officially open. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Associate Professor Dr. Muhlas MT for the speech. Ladies and gentlemen, entering the next event is a prayer, which will be led by Mr. Fauzan Muhammadi, LC LLM. We invite.
Assalamualaikum warahmatullahi wabarakatuh. To all the participants and all of the attendants, let's pledge ourselves, our heart, our sincerity and our faith in this occasion toward Allah subhanahu wa ta'ala, our Almighty God, to give dua, to ask His forgiveness. Bismillahirrahmanirrahim. Allahumma hamdan na'amin, hamdan syakirin, hamdan yafi ni'amahu wa yukafi mazidah. Ya Rabbana lakal hamdu kama yanbaghi li jalali wajhikal karimi wa azimi sultanik. Allahumma salli ala Muhammad wa ala ali Muhammad kama sallaita ala Ibrahim wa ali Ibrahim. Wabarik ala Muhammad wa ala ali Muhammad kama barakta ala Ibrahim wa ali Ibrahim fil alamin innaka Hamidum Majid. Allahumma ighfir lil muslimin wal muslimat wal mu'minin wal mu'minat al ahya'i minhum wal amwat innaka sami'un qaribun mujibud da'wat. Rabbana faghfir lana dhunubana wa kaffir anna sayyiatina wa tawaffana ma'al abrar. Rabbana la tuzigh qulubana ba'da idh hadaitana wa hab lana min ladunka rahmah innaka antal wahhab. Allahumma a'inna ala dhikrika wa syukrika wa husni ibadatik wa la taj'alna minal ghafilin. Allahumma ahrimna lazzata ma'syiatik warzuqna lazzata ta'atik. Allahumma arinal haqqa haqqan warzuqna ittiba'ah wa arinal batila batila warzuqna ijtinabah. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina azaban nar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Fauzan Muhammadi LC LLM who has led the prayer today. Allah subhanahu wa ta'ala grant our prayer. Amin. Ya Rabbal Alamin.
Ladies and gentlemen, the opening ceremony has come an end. We thank you for the author, co-author, presenters, and participants of this international conference who have attended the opening ceremony this morning.
Ladies and gentlemen, before we enter the first panel session, let's first witness the great performance of acoustic music from the Mabes Music Project. We welcome.
Assalamualaikum warahmatullahi wabarakatuh. Selamat datang Dahlan Muda di Fakultas Hukum Universitas Ahmad Dahlan. Fakultas Hukum UAD memiliki visi untuk menjadi fakultas hukum yang unggul dan diakui secara internasional dalam penguasaan ilmu pengetahuan dan keterampilan hukum, dijiwai nilai-nilai Islam dan semangat pembaharuan. Di Fakultas Hukum UAD, Anda akan diajar oleh dosen-dosen yang berkompeten, yang memiliki gelar profesor, doktor, dan praktisi hukum yang akan berikan pendidikan yang terbaik bagi Anda. Fakultas Hukum UAD juga memiliki fasilitas yang memadai, memiliki laboratorium ilmu hukum, memiliki kelas yang representatif, akses internet yang kuat, dan koleksi perpustakaan yang sangat lengkap, sehingga Anda akan mendapatkan ilmu hukum secara maksimal. FHUAD juga memiliki kerjasama dengan berbagai perguruan tinggi dan lembaga negara baik di tingkat nasional maupun internasional. Oleh karena itu, yakinlah bersama Fakultas Hukum Anda akan meraih masa depan yang gemilang. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Selamat datang rekan-rekan mahasiswa baru Fakultas Hukum Universitas Ahmad Dahlan tahun 2020. Perkenalkan, saya Witastianingrum SHLLM, Wakil Dekan Fakultas Hukum Universitas Ahmad Dahlan. Tugas saya di sini sebagai Wakil Dekan salah satunya adalah membidangi kemahasiswaan. Salah satu tugas saya diantaranya adalah membantu, mensupport, dan memfasilitasi Anda di bidang akademik maupun non-akademik. Kegiatan kemahasiswaan yang ada di Fakultas Hukum diantaranya adalah Badan Eksekutif Mahasiswa, Dewan Perwakilan Mahasiswa, IMM, dan organisasi-organisasi di bawahnya. Di antaranya ada Komunitas Peradilan Semu, kemudian ada LLC, CCLS, Sepakat, dan Legal Dance. Di dalam organisasi tersebut, Anda akan disupport secara akademik maupun non-akademik. Beberapa prestasi yang diraih oleh mahasiswa Fakultas Hukum secara akademik diantaranya adalah juara 2 Lomba Komunitas Peradilan Semu Franseda di Jakarta tingkat nasional. Selain itu, selama 2 tahun berturut-turut kita juga menjuarai PCTA Parade Cinta Tanah Air sebagai juara 1 di tingkat Daerah Istimewa Yogyakarta. Salah satu program unggulan kami diantaranya adalah mengadakan program student exchange atau mengirimkan mahasiswa untuk belajar di luar negeri. Mitra-mitra kami dari berbagai negara diantaranya adalah Universitas Utara Malaysia, kemudian University of Saint Anthony Philippines, dan satu lagi adalah National University Singapore. Selamat bergabung dengan kami, mahasiswa Fakultas Hukum, para calon sarjana hukum dan ahli hukum. Selamat bergabung dengan kami di kampus pembaruan. Wassalamualaikum warahmatullahi wabarakatuh.
Kulihat ibu pertiwi sedang bersusah hati, air matanya berlinang, mas Intan yang hutan, gunung, sawah, lautan, tetap cinta putramu yang setia, menjaga harta pusaka untuk nusa dan bangsa. Hutan, gunung, sawah, lautan, simpanan kekayaan. Kini ibu sedang lara, merintih dan berdoa. Menjaga harta pusaka untuk nusa dan bangsa. Okay, thank you so much. Thank you very much for the time given to us. Thank you very much to Ahmad Dahlan University and Law Faculty for giving the opportunity to make music here. Introduce us from Mabes Music Project and introduce from us. My name is Titi and my friends Rizal. So in the near future, we will accompany all of us friends by bringing some songs. And the next song, the second song. Hidup berjalan seperti bajingan, seperti landak yang tak punya teman. Ia menggonggong bak suara hujan, dan kau pangeranku mengambil peran. Pun kalau saat hancurku disayang, apalagi saat ku jadi juara, saat tak tahu arah kau di sana, menjadi jawab saat ku bertanya. Sedikit ku jelaskan tentangku dan kamu, agar seisi dunia tahu. Keras kepalaku sama denganmu, caraku marah, caraku tak tengah mati, seperti detak jantung yang bertaut. Nyawaku nyala karena denganmu. Pun aku masih tak mengerti banyak hal. Semuanya berenang di kepala. Dan kau dan semua yang kau tahu tentangnya menjadi gagah saat ku tak bisa. Sedikit ku jelaskan tentangku dan kamu agar seisi dunia tahu. Everybody singing. Keras kepalaku sama denganmu, caraku marah, caraku tersenyum, seperti detak jantung yang bertaut. Nyawaku nyala karena denganmu. Semoga lama hidupmu di sini, melihatku berjuang sampai akhir, seperti detak jantung yang bertaut. Nyawaku nyala karena denganmu. Okay, thank you so much. Okay, the last song will by my friends. Please welcome Rizal.
Maybe surrounded by a million people, I still feel alone. Just wanna go home. But I miss you, you know. I've been keeping all the letters out to you, each one a line or two. I'm fine, baby, how are you? But I was in the math, I know that it's just not enough. My words were cold and flat, and you deserve more than that. I'm now playing another sunny place. I'm lucky, I know. Just wanna go home. Go home. Let me go home. I'm just too far from where you are. I wanna go home. And I feel just like I'm living someone else's life. It's like I just sat outside and everything was going right. And I know you could not come along with me. Everything was going right. And I know the day has come and gone away, and even Paris or Rome, but I wanna go home. And I'm surrounded by a million people. I still feel alone. Just wanna go home. Let me go home. Let me go home. I'm just too far from where you are. I wanna go home. Let me go home. It'll all be alright. I'll be home tonight. I'm coming back home. So thank you everyone.
Assalamualaikum warahmatullahi wabarakatuh. Selamat dan sukses kepada Fakultas Hukum Universitas Ahmad Dahlan atas penyelenggaraan Ahmad Dahlan International Conference on Law and Social Justice pada tanggal 4 sampai 5 Agustus 2021. Atas nama Fakultas Hukum Universitas Muhammadiyah Kendari juga mengucapkan terima kasih atas kerjasama baiknya diberi kesempatan sebagai co-host pada kegiatan ini. Semoga kegiatan ini bernilai ibadah dan memberi sumbangsi pemikiran yang baik untuk kemajuan bangsa dan negara yang kita cintai. Demikian, nasrun minallah wa fathun qarib wa basyiril mu'minin. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. I humbly congratulate the Faculty of Law Ahmad Dahlan University Yogyakarta as the organizer of Ahmad Dahlan International Conference on Law and Social Justice 2021. I would also like to congratulate our participants for their enthusiasm and participation in this conference. This conference is not only an important event in exchanging ideas and knowledge, but also to create opportunities for greatest networking and cooperation between researchers. This conference is expected to promote the identity of the Indonesian nation and strengthen relation and cooperation in academic and non-academic fields. Our civic academic as well as other colleges from inside and outside Indonesia are expected to have the opportunity to exchange culture, history, and knowledge. This conference also as a platform to strengthen and enrich personal and professional relationships in their respective fields. This conference, the theme Law and Social Justice, Recent Challenges and Opportunities Following COVID Pandemic, is a theme that is very suitable for the current situation. It will be very interesting to listen and to get results from the conference discussions from this point of view. To all participants and the organizing committee of the conference, I wish you all the best of luck and a successful conference.
Assalamualaikum warahmatullahi wabarakatuh. We are on behalf of the Faculty of Law Universitas Ahmad Dahlan Sumatera Barat want to say congratulations and success for the first Ahmad Dahlan International Conference on Law and Social Justice, which held for until 5 August 2021. By theme Law and Social Justice, a recent challenge and opportunities following COVID-19 pandemic. The pandemic doesn't stop the spirit us to work. Thank you for the opportunities as co-host. Happy follow this conference to all participants. Good luck. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. We are the entire academic community Master of Law Study Program University of Muhammadiyah Palembang. We want to congratulations and fulfill success to the implementation of Ahmad Dahlan International Conference on Law and Social Justice. Hopefully, this conference activity launched by Allah Subhanahu wa Ta'ala until it's finished and will be producing quality scientific work. Once again, congratulations for Ahmad Dahlan University. We hopefully continue to succeed in educating our umat and whole nation. That is all speech that I can say. Thank you for the time. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Saya Dr. Diah Adriantini Sinta Dewi SHMHum, Dekan Fakultas Hukum Universitas Muhammadiyah Magelang, pada kesempatan ini mengucapkan selamat kepada Fakultas Hukum Universitas Ahmad Dahlan Yogyakarta atas terselenggaranya Ahmad Dahlan International Conference on Law and Social Justice. Apresiasi yang besar kami sampaikan kepada Fakultas Hukum Universitas Ahmad Dahlan Yogyakarta mengingat kegiatan ini dilaksanakan pada masa pandemi. Kami selaku co-host dalam acara ini berharap ke depan jalinan kerjasama antara Fakultas Hukum Universitas Ahmad Dahlan Yogyakarta dengan Fakultas Hukum Universitas Muhammadiyah Magelang semakin luas. Sekali lagi, selamat dan sukses untuk Fakultas Hukum Universitas Ahmad Dahlan. Sekian, wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, good morning. Dear Excellencies, distinguished guests, dear colleagues, ladies and gentlemen, as Chairman on the Universitas Ahmad Dahlan Board of Trustees, It is true pleasure for me to welcome you to the first Ahmad Dahlan International Conference on Law and Social Justice. I am very grateful to Professor Edward Omar Sharif Yarich, Vice Minister of the Ministry of Law and Human Rights, for taking time off from your busy schedule to attend this conference. I also wish to thank all invited speakers, Professor Stefan Kos, Bundeswehr University Munich, Germany, Professor Estrella Arroyo, University of Saint Anthony, the Philippines, Professor Yoongjun Kim, Hwangwon, National University, South Korea, Dr. James Press, Australian National University, Dr. Rohana Abdurrahman, University, Utara Malaysia, and of course, Dr. Nur Masari, Universitas Ahmad Dahlan. It is also an honor for me to welcome all participants, representatives from our partner academies, as well as experts from science, business, and politics to the conference today. The topic of today's conference is very eminent and timely to be discussed. The COVID-19 pandemic has challenged human civilization, governance, and legal system across the world. The priority is to sustain the scope of livelihood and uphold the sanctity of laws relating to all aspects of life. Healthcare must reinvent itself with more research and inclusiveness. In the post-pandemic world, law reforms will play a major role. Therefore, congratulations and success to the Faculty of Law, Universitas Ahmad Dahlan, for being able to organize this important moment. I'm grateful to everyone who participated in preparation and realizations of this conference. I believe that the work to prepare this conference that was done deserves an award, as well as everyone who devoted their time and effort to it. This conference is a great starting point for the next second one, and I hope that it will ultimately result in an even larger success due to collaborations and creative potential among all participants. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Since 1960, we have been trying to contribute to the nation by developing and optimizing the potential of the people through education. Every year, more than 7,000 new students from within the country and abroad enroll in UAD. With innovation, technology, and creativity that are based on intellectual and moral integrity, perfected by Islamic values, we create a comfortable and stimulating learning atmosphere. The public trust in us is proven by the increasing number of new students from year to year. Currently, there are more than 26,000 active students from various regions of the country. Our continuous internationalization efforts are shown with the distribution of foreign students at our university from various countries. The high-achieving climate developed at the campus supports our chosen students to compete in various competitions, both at national and international levels. We equip students with the required experience to participate in various international cooperation programs through joint degree, double degree, short course, summer camp, and competition programs at international level. As a Muhammadiyah higher education institution, we make Al-Islam and Kemuhammadiyahan as the foundation for our campus life. Fun learning with various activities are promoted to develop the potentials and interests of the students. The students' organizations and 3 Muhammadiyah autonomic organizations that we offer are the best choice for students to channel their interest and potentials, both in academic and non-academic activities. With the increasingly fast technological advances, we improve the quality of our internet connection for comfortable online learning through e-learning, as well as for various payment and tuition transactions. We have a smart room that can integrate all campus management information system that is displayed on executive dashboard system, making it convenient for immediate decision making and providing fast and optimum services for lecturers, educational staff, students, and their guardians. Besides, we can also carry out social media analysis, teleconference, or online meeting. With more than 750 competent educators with the best qualification in their fields. Since 2017, we have been accredited A by the National Accreditation Board for Higher Education. Besides, we also managed to record a variety of notable achievements. Working to provide quality education with the best learning system for our students. Now, we have 11 faculties and 52 study programs for both undergraduate and postgraduate programs. Adequate facilities, friendly services, professional educators are our focus. Comfortable classrooms, integrated laboratories, amphitheater with 3D facilities and smart presentation, observatory, as well as libraries with complete collection are utilized to support students' learning activities. Education, research, and community service are the main objective for higher education. In terms of research, we are trying to create a conducive research climate. We are also working to encourage lecturers to continue improving their research to produce a variety of innovations that are aimed to benefit the society through appropriate and efficient technology. Our target in scientific publication in the form of books, publication in accredited national journals or reputable international journals continues to experience a significant increase. With 78 journals in various fields of science, 33 SINTA accredited journals, 3 of which are Kampus Index, UAD is the first and only Muhammadiyah higher education institution with 3 reputable international Kampus Index journals. Moreover, UAD also records an achievement in the field of community service by getting recognition and transforming from very satisfactory cluster to a superior cluster. We built a strong network with various institutions, organizations, and universities proven with various track records in national and international corporations. The corporations established promote activities in the fields of education, research and community service with seminars, workshops, publications, and various other programs. We are forging multi-year cooperation with the European Union Erasmus Plus through the capacity building for higher education program in the development of entrepreneurship and disaster management. Alumni are valuable assets for a university. For that, we are continuously improving the quality of our graduates. To know the competency of our graduates as workers, we conduct a tracer study by maximizing the participation of alumni through KAMADA, Alumni Associations of Universitas Ahmad Dahlan. For the development of science-based business economy, we have a number of business units: PT Adi Multi Energi, PT Adi Multi Kalibrasi, PT BPRS Karana Kiat Andalas, PT Adi Multi Husada, PT Adi Multi Teknologi, PT Adi Multi Property, PT Adi Multi Boga, and PT Adi Multimedia.
Ladies and gentlemen, Next, we will start the first panel session. In this first session, 3 speakers will be present. Professor Dr. Stefan Kos from Bundeswehr University Munich, Germany. Professor Dr. Hyun Jung Kim from Kanwon National University Republic of Korea. And Dr. James Press from Australian National University, Australia. We have Miss Uni Sulasi Putri SHMH to guide the first panel session.
Please allow us to read of a brief CV of our moderator in this first panel session. Mrs. Uni Sulasi Putri SHMH, she is currently a lecturer at Faculty of Law, Universitas Ahmad Dahlan. She is graduate of the Universitas Islam Indonesia, and she has completed her postgraduate degree from Universitas Gadjah Mada in 2008. She is currently working on research on comparative analysis of equity crowdfunding in Indonesia and Malaysia. Then, we invite Mrs. Uni Sulasi Putri SHMH to guide the first panel session.
Thank you, Madam and Sir. First of all, can you hear and see me well right now? Okay. Yeah. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Thank you all for spending time and attending today's conference virtually. Before we start the panel session, we are going to have 3 speakers with 20 minutes time allocation for each speaker. We will open the Q&A session later until 12:10. And therefore, for any attendees and participants here who are willing to have a question, please write them down to the chat or raise your hand during the Q&A session later. Then we will choose some participants' questions to deliver their questions directly. During the speech, please turn off your microphone and turn on your camera. Ladies and gentlemen, the emergence of COVID-19 outbreak has led to the alteration of human life. Let us see now. We used to have an international conference physically, face-to-face, somewhere in a place. But now, luckily, we have this technology, make it possible for us to meet each other without any physical contact to avoid the spread of COVID-19. However, how would this technology affect the law in the future? To address this issue, we invite Professor Dr. Stefan Kos, Professor in Bidang University Munich, Faculty of Economics and Organization Science, Germany. He received postdoctoral qualification at the University of Confrence in 2002. He was a judge at the District Court of Roda in 1994, and he has been a temporary consultant of the World Bank in the World Bank project. Now, he is a visiting professor as well in Business Law Department in Binus University, Yogyakarta, Universitas Airlangga Surabaya, Universitas Islam Riau, and Universitas Muslim Indonesia. Good morning, Professor Kos.
A very good morning.
Yeah, thank you, Professor, for coming here today. Now, please take your time to deliver your speech.
Terima kasih banyak, Bapak Ibu. Saya mau berterima kasih atas kesempatan ini kepada komite, kepada Bapak-Bapak Din, dan juga mau berterima salam ke teman saya dan koleg saya, Dr. Fitriatus. Saya tahu Dr. Fitriatus sudah lama. Waktu pendek, so I will start now and I will talk in English, of course, because for the presentation my bahasa is not good enough. So what a strange time we have, right? We have already the disruption by the internet, which led to ubiquity and to a technical disruption and technical globalization. And I want to show today I hope I will be able to manage that in 20 minutes. That this disruption led to another disruption, which is a social disruption, and which is a very negative view, which is maybe a crisis not only for the international law, it's also a crisis for the social justice. I hope you can see my presentation. Yes. So let us start with the technological conditions of the era. As I mentioned already, that is something which is bothering me already since years. This is nothing new, that the internet led to ubiquity. Internet is everywhere, so we see more and more the disappear of territoriality and of borders. So this is, of course, an aspect of a crisis which it's a crisis for the legislation of the states and therefore for the sovereignty. This is one of the factors. The other factor, of course, you mentioned that already, the acceleration of the digitalization, which led to faster development of new and disruptive digitalization technologies due to the pandemic. And this is also coming together with another crisis of the law and another crisis of the legislation, because we all use instruments which are actually not allowed. So for me, it's actually not allowed to use Zoom due to data protection regulations of the European Union, but we make it, we do it because we're very pragmatic. So I will mention that again. This is the aspect of the pragmatization of the law, which is not only positive. And the third thing is the rise of the digital platforms and the big data monopolists. This I don't want to go into the deep too much because this is really nothing new. If we talk about Google or Amazon or these things. So the first aspect which I want to point out for that is the loss of the sovereignty of the states due to the ubiquity. And this is a very, very important aspect, as the borders are not longer valid, as the borders are not longer determining for the regulation of the social conditions. We see more and more the internet replacing this. And this is, of course, an aspect which will be followed by the loss of importance of the law, of the state law. As we have not a good option to have a global law, we still need the state law for regulate social conditions in the territories of the states. Now, Niklas Luhmann, a famous sociologist from Germany, mentioned already a long time before, and not connected to this issue, that lost trust in the law by not enough enforcement or not enough power of the law, of the state law, leads to the longing for alternative safety. And I would like to show that this alternative safety is found by the society, unfortunately found by the society, by the technicity. Now, let's start with one aspect which shows that very good. This is the aspect of the data protection. We all know the new developments of the augmented reality, and this is just the one example. Augmented reality glasses on one hand are very striking, very nice and very good thing, but on the other side, if we have glasses which are connected permanently to the internet, scanning people, and are produced in maybe totalitarian countries, which are not maybe obeying the rules of data protection and personality, then we have a problem, because anyone can scan anybody and this one will not know that he is scanned. So how we can regulate it? And the answer is, actually, we cannot regulate it at all unless we make prohibitive legal regulations on this. So if we don't want that personal data of citizens are transferred to countries like China, then we will have to forbid these data protection issues, these data protection instruments, these data transferring instruments, or we have to pragmatize the law. Because there is no control of it. So we can say, okay, any company is forbidden to transfer the data to non-safe harbor countries, but how to control that? Unfortunately, these instruments are already in the market and cannot be stopped anymore. And the question is, do we want to stop it? Because if we stop it, then we would, of course, also stop innovation. So European Union, as the example of my own home territory, cannot lock out itself from technical innovation. So actually, the states have no choice than to not prohibit strictly these instruments and these gadgets, and strive for regulation somehow. Now, the data protection regulation of the European Union is quite a strong instrument in the moment. The legislative claim of control by the European Union by issuing the data protection regulation led to a success in the way that international companies, international concerns are mostly obeying these regulations due to the importance of the market of the European Union. Whether that the Chinese companies will respect this regulation is another thing, but American companies mostly respect that. Now, there is nevertheless a clash between this legislative claim of control and the reality of the ubiquitous society, because the society is choosing which instruments they use. And if we not prohibit this instrument in the market, then people will use it. Now, how to deal with that? In my opinion, and this is the first aspect of this, replacement of the law by technology and by factuality, is the pragmatizing of the law. This is the only way we can do actually in the moment. We can say, okay, the people are willing to give out their data to anybody or to companies or to other states and are not caring for that. Anybody is posting anything in the Facebook or in social media. So maybe the society changed. So maybe the society doesn't want to be protected anymore. So maybe the state should just teach the society to be careful with its own data and give the responsibility to the people. I don't say that I think this is the right way, but I think this is maybe the only way. So this I call the pragmatizing of the law by harmonization on the lowest international level. And the lowest international level, of course, is the level of non-data protecting markets, which is not the European Union. This is also an important international law aspect, as I call it, the law of the strongest on one side, because the law of the strongest means that strong markets and strong political powers still have the opportunity to regulate in a certain way by their national regulations, and also impose an extraterritorial application of their legislation to other countries. Now, of course, European Union in a moment has the power to regulate something and it is respected internationally, at least partly internationally. Of course, China has this opportunity. Of course, the United States has the opportunity. But if we come to Indonesia, then the question is, has Indonesia the market power and the political power to impose their regulation on hate speech, for example, or whatever, internationally? And I don't think so. Now, this is a crisis of the international law, indeed. Yeah, because normally we should have the international public law aspect of the courtesy of the countries against each other. But now we have the law of the strongest. Now, is this just? No, it is not just. Is politics just? No, it is not, mostly not. It is self-defense of a national regulatory system, which is not able in another way to protect the citizens by national territorial limited regulations anymore. This is a crisis indeed of the international law. Now, let's come to another aspect, the replacement of the human factor by the technicity. Now, concerted acting of AI entities, artificial intelligence in the market are a good example of how the human factor is more and more replaced by technicity and technology. Now, we have already examples where AI algorithms are collaborating in a way to regulate market or to influence markets, for example, by observing the market and then adapting prices of a company. A good example is Lufthansa, which used an algorithm like that some years ago when some concurrent in the local market was going bankrupt. Now, what will we do if AI algorithms are independent and then collaborate to each other and do exactly the same what companies led by people would do if they want to influence the market in a cartel? Now, the cartel, the antitrust law in the moment is bound to behavior, market behavior. And we don't have any instrument in the moment. There will be regulations, maybe how valid these regulations will be in the reality of the market, we will see. But in the moment, all the terms of the antitrust law, of the competition law, are bound to the aspect of behavior, and AI cannot behave because AI is determined. So we see a shift from behavior to determined action by technology. Another good example. Could you switch off, please, the speakers there? Could you switch off them, please?
Yeah,
thank you. Another aspect is the aspect of contracts by AI, which is very interesting. I'm coming from the civil law, and this is one of my most interesting aspects. In the moment I do research on the AI. If AI makes contracts, and we have two algorithms making contracts, and we have already starting of regulations on that, integrating AI into the contracting law, then we can, of course, see this pragmatical and say the AI, the algorithm, make a contract with another algorithm, and then let's make it like analog to the contracting of people. But this would mean that we abandon the principle of the private autonomy, because the private autonomy is bound to the personal freedom of the legal subject. The legal subject has the right to choose whether it wants to make a contract, with which aspects they want to make a contract, or whether it wants to choose the contractual partner. But an AI, an algorithm, cannot choose, and an AI cannot wish. So if we accept that AI make independent contracts, independent from any influence of human beings, then we would have to have a new terminology in the civil law, in the contract law, which is, and we must be very clear of that, which is leaving the basis, the constitutional basis of the civil law and of the contract law in the private autonomy, in the personal freedom, because AI is simply not free. And the third aspect, this is just three aspects. I will elaborate it more in a journal article which is already prepared. The third aspect which I want to highlight is the aspect of the upload filter and hate speech detectors in the social media. We have now a new legislation in Germany and in the European Union which regulates that social media platforms such as YouTube must decide and must filter infringing uploads, especially infringing against the Hak Cipta, the copyright law. I don't want to go into the deep to that, but it is clear that they cannot achieve this goal to filter that in the legislative adequate way without using algorithms which are filtering full automatically everything which is uploaded. This means in the future, you have algorithms deciding what you can express in the public on platforms. And if this is spreading, then we have a problem we have to at least discuss if algorithms decide about free speech of the human. So these three examples, I think, are enough to show how the human factor in the law is replaced by technicity. And this shows another very important point, the loss of the importance of the law in the digitalization 5.0, which this is too fast, which is have four aspects. First of all, we can see that the interpersonal trust between the legal subjects and between the person is replaced by determinism, by technology. If we see, for example, the example of smart contracting. Smart contracts are algorithms which are programmed before, and then they will execute full automatically when certain conditions are fulfilled. This is an aspect of a replacement of interpersonal trust and of the human factor, because you don't have to trust your contractual partner anymore. This is one aspect, because this contract is executing automatically by the algorithm. And second, it's also replacing the trust into the legal system, because you don't need the law enforcement by courts anymore, because these contracts are executing automatically. So I have a doctorate from Israel who's working on that, how the smart contracts are replacing courts and court decisions. Second, the trust in security and control by technology as a consequence of the loss of trust in state protection. As I mentioned, Niklas Luhmann, the law enforcement, due to the ubiquity, is not that strong enough anymore as it should be to protect the citizens and to regulate the social conditions in the state territories. So what is the consequence? Once we have an instrument to replace this not very strong law enforcement by the states anymore, we will use it. And it is used already, for example, by the blockchain technology or also by smart contracts, which give us a security which is technological security, not security by protection of courts or protection of legislation. We just trust that something in the blockchain is fixed and can be proven, and this is the technology. This is all. Yeah, this is a replacement of the trust in the security and the control by technology. Then third, the automatization and the determinism instead of incentives. We will not need so much incentives anymore to comply with the law, as we have automatization by smart contracts, by AI, by blockchain technology, and then also, especially by AI, the determinism. Determinated action and not emotion, and the loss of the constitutional basis of the private law by abandoning the freedom concept of the private autonomy. Most important to me seems that the emotion is dilated more or less by the technology from the social conducting or from the social regulation, which is on one side good. Many people say, oh yeah, AI judges is good, then the judge is faulty and so, but exactly the faultiness of the judge is a question of human dignity, that you have the right to be in front of a human judge who has a good day or a bad day. This is the risk, and also the chance of you in front of a human court. Now, what is the consequence of that? The determinism instead of emotional flexibility is one of the consequences. Elimination of the relevance of behavior. I mentioned that already in my examples. So if we compare the approach of human-centric artificial intelligence in the new EU regulation, which is planned to AI, then we see that the EU sees that and tries to fight against that, bring this emotional flexibility and this human-centric aspect into the AI. I don't know if it works. And it's also a question of the human dignity. Second, the determinism instead of the normativism, we will not evaluate so much anymore, because anything is determined by the technology. And you will agree that in the moment and in the near future, AI will not be able to evaluate in a way that it is also taking into account aspects which are not rational. And third, the utilitarianism instead of other ethic concepts, which will be stronger. For example, how equality, how justice, how freedom is integrated into the decision if the technology replaces the legal decision by humans. And this is not my idea. This is an idea my colleague, Dr. Shidata from Binus University 2 weeks ago presented in another presentation. He's very concerned on the integration of these aspects, these soft aspects like equality, justice, freedom into the law, if the technology gets too strong. Now, if you compare that with the social state principle and the corporate social responsibility, this might not be compatible. If we compare it with the economic analysis of law, then it may be something similar, and I already criticized that. Now I come to the end. What is the role of the ethic and the justice in the future? I don't know that. Lessig, some American researcher from in the year 2000, mentioned the West Coast Code and the East Coast Code. The East Coast Code is Washington, the West Coast Code is the Silicon Valley, and both are codes which are competing with each other. But in a moment, it seems that the West Coast code is stronger than the East Coast Code. And how we integrate the ethic and the justice if the programmers have the power, and later if the autonomy of the AI has the power. We can, of course, force the programmers to integrate justice and ethic into the programming, but how we force them? And what if the AI is independent of the programming? Then we have a real problem to integrate these aspects which actually belong to the law. And this is unfortunately a crisis of the law. Now I would like to finish with this citation of Madame Verstager from the European Commissioner for Competition. She said, on artificial intelligence, trust is a must, not a nice to have. With these landmark rules, which is the new legislation of the EU on AI, the EU is spearheading the development of new global norms to make sure AI can be trusted. Well, I'm very pessimistic on that. I don't think this will really work. In the moment, it will be work, but the more independent the technology is from the human development, then it will not work anymore. Now, let me just give you the hint. I will elaborate it stronger. 20 minutes is not much, so I will finish now. And these are the references you will find in the presentation. And now I thank you for your attention, and sorry for the 2 minutes longer than what was given to me. Thank you very much for not interrupting me, as it is sometimes in other conferences the case.
Yeah, thank you, sir. Yeah, because we are too early, 5 minutes. So yeah, I give you like 2 minutes later after.
Then we can later discuss more.
Yeah, sure, of course. Thank you very much. Thank you for the thorough explanation of the technology, digitalization, and artificial intelligence. Now, ladies and gentlemen, COVID-19 outbreak, instead of giving an impact to the technology, it also raised an issue of justice. It happens nearly worldwide, not only in Indonesia, it also happens in South Korea. And therefore, to address that issue, we invite Professor Hyun-Jun Kim, the professor in Kangwon University, Department of Cultural Anthropology, South Korea. He will address the issue of how the COVID-19 outbreak raised an issue of justice. Dear Professor Hyun-Jun Kim, please.
Yeah. Terima kasih Mbak Yuni. And good morning, everyone. And I'm very glad to be here at the first Ahmad Dahlan International Conference on Law and Social Justice. And I'm very I would have to say thanks to the Papa Rector Muklas, then the Dean of the Faculty of Law, Rahmat Muhadzir, then the head of the committee of this conference, Muhammad Noor. And before I go to my presentation, yes, I share my presentation first. Yeah. Before I go further, I have to confess that I'm not a specialist on law, and I'm not a specialist on Korean society. I'm actually an Indonesianist working on Indonesian Islam, especially Muhammadiyah. So in that sense, what I present today is not a very analytic paper on the situation of Korea under COVID-19. I observed some phenomena in Korea as a citizens of Korea. So what I present today is quite descriptive, but I expect it will be materials for you, the law guys, to think about how the COVID-19 can impact on the concept of social justice. The title of today's presentation is something like, justice for those suffering COVID-19. And we Koreans have some sort of debates on the distribution of the just subsidy in Korea. So I'll share the experience of Korea with you for you to think about what's happening in Korea, and you may be get some insight on how the concept of social justice can be debated. Actually, the condition of Korea under COVID-19 is not that serious compared to other countries in East Asia. So we can actually control the number of new confirmed cases under 2,000. But still, as you can see the graphs, we have some, internally, we've perceived some sort of waves of COVID-19. So we are saying we are experiencing the fourth wave of COVID-19 in Korea. And responding to the pandemic, the Korean government tried to help those who suffering from the COVID-19. And actually the major target of the government response was small businesses and laid off workers, or those on leave of absence. So when the government distributed subsidies to them, there was no objections. There are some sort of consensus that the subsidy should targeting at those who suffer the most. But about 2 months ago, the Ministry of Finance in Korea proposed a very strange but novel subsidy scheme to boost consumption at the national level, saying that they are going to widen the target of subsidy at 80% of the total population. So before this time, those who received subsidy from the government may be, I think, 50% or 30% or something like that. Those who, the very target who suffers from the closing down of the shop or something like that. But suddenly the Ministry of Finance said that they will widening the target of the distribution of subsidy. And this proposal has sparked a very heated debate among Koreans. And I divided it into 3 phases. And the first one, at the first phase, we are thinking about how to choose the right 80%. And there are some talk about income or assets, or we all Koreans paying health insurance premium. So they are using, there are some who are saying that we have to use health insurance premium as the criteria to find out the right 80%. And at the second phase, the debate goes to the more fundamental question of why 80%. So there are some who are saying that the recipients should be reduced to those suffering the most. It should be reduced maybe 30% or 40% who really desperately need assistance. But on the other hand, there are some who started to saying that all citizens should be included into the subsidy scheme. And then at the third phase, the debate goes to what is the just way to distribute subsidy under the pandemic. So these are the topics that I'm trying to say today. And before we go further, yes, of course, as I said, I'm a novice to the debate on the concept of social justice or something like that. So I just read some of the literatures and found out that there are several views on the concept of justice and welfare. And I think these perspectives are well represented in the Korean discourse on the justice distribution of subsidy. So there are some Koreans who are talking about justice based on utilitarian theory. So they are saying that the maximization of the total welfare should be considered to distribute subsidy. So they are saying subsidy for all or for the majority of population to maximize economic efficiency. And there are some groups supporting John Rawls' theory of justice and fairness. So they are saying that subsidy should be reduced for those affected the most by the pandemic. And there are some which could be who could be classified as supporting communalistic view. So they are emphasizing social values and solidarity rather than the effectiveness or maximization of the subsidy. At first, as I said, the debate starts with how to choose the right 80%. Actually, the 80% were presented by the ministry, and they say that 80% are those whose income has decreased under the pandemic. So, but I think the rationale is not that strong. The reason is something like improvising, because what they thought was that they had a fund and they think about $230 is enough, and they divided it and make it finally that we will give it to 40 million, namely 80% of the total population. But there are some alternative views that saying that we have to find out more accurate ways, or we have to reduce the number of recipients. That's the first phase of the debate. And the second phase goes to the problem of the arbitrariness of the 80%. So they are talking about alternative and newly emerging views that the government have to give the subsidy to all. So in the debate on why 80%, there are several views saying that it is difficult to choose the group suffering from the pandemic. So the administrative cost is too high, so you have to pay it all. And there are some who are saying that the most effective way for economic recovery is providing subsidy for all. And there are some who are saying that you have to give it to all because all have suffered from COVID-19. And there are some who are saying some more radical way that everyone is entitled to be cared by the society. So there are several positions who are supporting the alternative view of giving subsidy to all. And as you can see, there are some survey results and on the subsidy, and there are slightly more than half of the population of Korea support subsidy to all, and slightly less than half support the view that subsidy should be selective. These are the survey results on subsidy. But in case of internet discourse, actually, I think there emerged some dominant views. So in the internet, so those who are more vocal to express their views, they are saying that the government should stick to equal distribution. And these are some of the rationales they are giving to support their argument. So they are saying that we all are citizens, we are the same. And there are some who are saying that high income earners are also exhausted, both physically and mentally. And this sort of discourse or opinion is quite extraordinary in the sense that before the coming of pandemic, we have never thinking about the welfare of high income earners. So we always think about those belonging to the poor, those who are suffering. So most welfare policy or views on social justice usually do not consider seriously on high income earners. But during the pandemic, I think those who does not belong to the high income earners, they are thinking about the position of high income earners. They are also citizens. They have also suffered from pandemic. So why the government should not support the well-being of the high-income earners? It's something like quite different perspectives, and the perspective that I have never heard before. We never talk about the high-income earners before. So I think they are asking about what is democracy in the case under the condition of the pandemic, and they are thinking about justice, discrimination, or something like that. So when we always think about discrimination, we usually think about the group of the weak. But in this case, when we are talking about discrimination, is discrimination against the wealthy, the most privileged groups in Korea. So this is some sort of a brief course analysis of mine. So actually modern states, we are saying that it is something X-like and it is perceived as community, but actually it is not a community per se. So in the social science, we are saying that the state is something like an imagined community, not a real one. But what I'm thinking is that the COVID-19 helps us to feel the imagined community more realistically and empathetically, because persons whom we meet in the street can impact on our life. So with this sort of experience, we have a perception, we have a much more stronger perception that all citizens are interconnected. So I'm thinking that the COVID-19 has strengthened the appreciation that all citizens are under the same position, whether it be rich or poor, young or old, and so on. So the perception of commonality among citizens has been reinforced. And with this, it emerges a new consciousness of justice. We all suffer from COVID-19, so there should be a form of subsidy for all. We should not discriminate the rich against the poor, or the suffer the most from the ordinary persons. So I think this is a very strange experience for me, because ordinary citizens are suddenly thinking about the strongest, the wealthiest. So there are some very humorous ones. You know that the conglomerate Samsung its birthplace is Korea, and the president of the Samsung, and he is now in prison, but anyway, he's something like, his name is Lee Jae-yong, and people are saying Lee Jae-yong has to be given some subsidy, like me, just like me. So even if it is a small money, but we are saying that we are friends, we are brothers, and we are something like that. So I think social solidarity among Koreans has been strengthened. So this is the last part of my presentation. COVID-19 has prompted Koreans to appreciate the connectedness of citizens belonging to the same imaged community. So with this previous consensus on the justice redistribution of wealth, that is for selected, it should be selected for the deprived, is re-examined. And the sense of community allows an emergence of a novel view on social justice. All should be carried by the society, irrespective of their differences. And some politicians and some social activists were involved in this debate, and they are proposing some discourse which includes the notion of universal basic income. So they are saying that with the case of pandemic strengthens the basis that the government should provide universal basic income for all citizens. So what I can say at last is that the debate on the subsidy teaches us that justice is contextually defined. Yeah, it is a very obvious fact, but that's the only conclusion that I can present today. So as Michael Sandel tells us, public debates and deliberations on the very basic idea of justice can be the key to produce contextually and culturally relevant meanings of justice. So that's the experience of Korea under the pandemic, and I hope I just provided the raw material for analysis, and you the participants of this conference who are specialized in law and discussions of social justice may use the case of Korea for thinking about how the concept of social justice can be formed. Yes, that's all. Thank you for. Terima kasih banyak atas perhatian. Yep.
Yeah, sama-sama, Prof. Thank you very much as well for giving I think it's going to be a very great fact to hear about what happened in South Korea comparing to Indonesia right now, because subsidy and justice becomes a very big deal right now in Indonesia, especially because we are now imposing restrictions on community activities. And having a subsidy for society is something very a big deal. Yeah, thank you, sir, for giving us an issue that we can discuss later. Now, moving to the third or the last panelist of the first session. Ladies and gentlemen, on April 2021, the World Meteorological Organization released a flagship report saying that in 2020, COVID-19 added a new and unwelcome dimension to weather, climate and water-related hazards with wide-ranging combined impacts on human health and well-being. Mobility restrictions, economic downturns, and disruptions to the agricultural sector exacerbated the climate events along the entire food supply chain, elevating levels of food insecurity and slowing the delivery of humanitarian assistance. The pandemic as well disrupted weather observations and complicated disaster risk reduction. And therefore, considering the climate change law and climate change crisis, what can we learn from the response to the coronavirus crisis? Coming here to respond on the issue, Dr. James Press, who is an honorary senior University Institute for Climate Change, Energy and Disaster Solutions, as well as lecturer in Australian National University College of Law in Australia. He is an environment lawyer with 26 years experience, including 15 years as environmental researcher in Australian National University. Good afternoon, Australian time, Dr. James Pratt. Yeah.
Terima kasih.
Please take your time, sir.
Thank you. It's a great honor to accept the invitation to make a contribution to your conference. And the title of my paper is Climate Change Law and the Climate Crisis. What can we learn from the coronavirus crisis? So let me say a few introductory words and also just to select the screen to share with you. So please bear with me for one moment. Okay, just seeking to get the correct screen for you. Hold on. Okay. How are we now? Is this okay?
Yeah, it's okay, sir. We can see the screen right now.
All right. Terima kasih. So this just is an overview of my presentation now. I'm going to talk about the similarities between the climate change crisis and the coronavirus crisis, I'm going to refer to international climate change law and quite a lot of details of the national and subnational or regional climate change law. But because I'm in my study and professional work focused on solutions to the problem of climate change, I'm very focused on the law of clean energy. Okay, so this paper in some way comes from a request from the organizers to talk about the issues of disposal of plastic waste from the medical waste as a response to the coronavirus situation. Really, it's not so much within my focus of research to speak about waste management law, and particularly in Indonesia. But so I'm going to refer to some general principles relating to, I suppose, the policy response to environmental problems. So in particular, how we deal with environmental externalities and the appropriate role for direct regulation and for market-based approaches, and the limitations of both of those approaches. Right, so let's continue. So if we look here in relation to the corona crisis, we can see that data is important and science is important, and the scientists have had a key role. We saw in the United States during the Trump era, the contest between politicians who sought to deny science and they deny the role of medical experts in responding to the coronavirus crisis. And there were parallels between the denial of the science relating to climate change. So in confronting the problem of climate change, we have to look carefully at to what extent is the legal system oblige us to take account of scientific findings, and to what extent does our legislation allow for the politicization of the science. So these are kind of some of the common elements here. Okay. Some other themes that arise, of course, are relating to what is the role of the state during an emergency. Because in Australia, there is a debate, as there is worldwide, about climate change as a climate emergency. And it's typically seen that in an emergency situation, we have a declaration by government of a state of emergency in which some liberties of the individual may be taken away in order to respond adequately to the emergency at hand. So if we frame climate change as a climate emergency, then that raises questions about to what extent should the state or government have the role to take unilateral action to respond to climate change. But let's step back from that detail for a moment and say, in relation to the coronavirus crisis, obviously this is a global problem. We can't act unilaterally in cities or regions or countries in response to this problem, although it's necessary at each of those geographical stages, geographical scales to respond to the crisis. But we can see that this is a problem requiring global cooperation. And that's why, again, perhaps it's of concern that the United States took an approach of seeking to minimize the role of the World Health Organization and to downplay their contribution to solving this problem. So broadly, this is the same situation I've been describing here. How should we respond to the coronavirus crisis? And I think what we've seen is that in Europe, governments have sought to stimulate economies, as they have in Australia and United States, and I'm sure also in Indonesia, because of the economic contraction associated with the lockdowns, with closing public areas and workplaces for public health protection. We've then seen the need to stimulate economies And governments that previously would have taken a approach of avoiding public spending have been disrupted from their unwillingness to adopt Keynesian economic policies, but instead we see this blatant, willingness to stimulate the economy through spending. So one of the questions arising here is, how should governments spend money to respond to the coronavirus crisis? And in Europe, we've seen the Green New Deal and an attempt to use the corona spending in order to respond to the twin crisis of the environmental crisis and the climate change crisis. Whereas in Australia, we have seen an approach described as the gas-led recovery, where the federal national government have sought to provide or to use this crisis as an opportunity to stimulate spending in the fossil fuel sector for support for the gas industry. So this, of course, is controversial in Australia. There's a lot of opposition to that approach, but there we have it. So there is a fundamental choice here for governments that wish to stimulate the economy. How would they like to do this? And we could see that responding to the environmental problems in a direct way is an opportunity to get two benefits. Okay, so in terms of climate change, the evidence here is very clear about the increase in the atmospheric concentration of CO2. This is something that is being recorded by scientists with physical measurements. There's multiple independent lines of evidence to show that there is a climate change problem, and yet still we have a disjunct with some politicians refusing to accept that this problem of anthropogenic or human-induced climate change is actually a real problem. Many politicians are still in denial about this. Perhaps this is only in Australia and United States, but I suspect that there are nations throughout Southeast Asia where there is also climate change denial and a refusal to engage with the science relating to climate change. But this is one of the questions. How should we respond, and how, as lawyers and lawmakers, should we respond to the question of each nation's contribution? Now, this raises the question of international law, because the provocative question here is, if international law was so effective at responding to climate change, why then are we not seeing a flattening of this rising curve in the Keeling curve, which is this curve we see displayed on the screen? Okay, now one of the other aspects of this is that we can see that the scientists have done measurements to extract the air from inside the ice cores that you can see on the screen now. And this shows us that the computations from this scientific work show us that the level of CO2 in the atmosphere is the highest that it has been for the last 800,000 years. So again, this is the science in relation to the problem. Yet we have the human tendency to avoid looking at the implications of these scientific findings. So this is a question for us as lawyers: to what extent should the law take account of science and the findings of science to set some policy objectives? Now, the scientists are speaking clearly through their own journals. They are speaking in terms of climate emergency. This is a paper published in the journal Bioscience, November 2019. They're saying scientists have a moral obligation to warn of catastrophic threats and to tell it how it is. And they have used the phrase climate emergency. 11,000 scientists signed this scientific paper. Okay, so let's turn to the Paris Agreement. Governments are going to meet in Glasgow in November of this year. And the Paris Agreement has this target of 2 degrees and ideally well below 1.5 degrees by mid-century. So this is set out in Article 1A of the Paris Agreement. And as you probably know, that each nation sets what's called a nationally determined contribution in order to respond to this. And the Paris Agreement has the approach of allowing national flexibility. So each nation can make its own promise as to the contribution that it would like to make. So how does this connect with the coronavirus, etc.? Let's come to that point now. But one of the things that we have seen in terms of lawmaking at the national level and subnational level is that we've seen increasingly the passage of new laws in the year 2019, 2020, 2021 to set what are called net zero targets by 2050, the year 2050 or earlier. And that is based broadly on Article 4 of the Paris Agreement. Okay. So this scientist phraseology, terminology of the climate emergency has been echoed by popular movements and the school children striking for climate action, and that we have seen that this terminology of climate emergency is broadly related to the introduction of this climate legislation. We can't say that the two things are directly related, but there is some interesting interrelationship between these two factors. Okay, now in Indonesia, we have now some signals of a stronger response to the climate change situation, and we'll come to a discussion of the carbon tax proposal in Indonesia soon. Now, Australia has its own experience with carbon pricing, as does, of course, Europe and Germany and South Korea. Okay, so to bring things closer to my hometown, and also to my hometown is Canberra, the national capital in Australia, and to picture here of Bali, we have a closer example of an environmental externality. And this environmental externality is the individual's use of one single-use drinking containers, which then are thrown away. And so economists would see this problem as being an example of a negative externality of the private use of this product with environmental consequences. So in my hometown, we passed legislation to place an economic charge on each of the drinking containers, so that there could be money for the citizens if they keep the bottle and return it to the recycling center. Then they can receive a small amount of money to keep this plastic waste away from the environment. Now, so there's a clear example of a market mechanism in environmental lawmaking. And I would be suggesting that if Indonesia does not already have this type of legislation, that it needs to consider seriously this as a way of dealing with marine pollution and river pollution. However, if we were to apply this to the medical waste situation, I don't think it's so easy to apply a container deposit legislation to that problem. Still, it may be possible to design legislation taking account of financial incentives to reduce waste. So the principle of international environmental law that we would apply is the polluter pays principle. And so the idea is to place a charge on organizations. The more waste they produce, then the more that they would pay. However, the question is whether we would suspend those charges in terms of the response to the climate emergency, given the need for protective personal equipment. Okay, moving along. All right, so vaccination is another aspect of the externality analysis of public policy problems. So vaccination is an example of a public policy which produces a positive externality. In other words, the action by the individual to receive the vaccination produces a social benefit in addition to the private benefit. So here, if we can reduce the price to the individual of receiving the vaccination, then we can increase the amount of uptake of the vaccination. And I think that certainly we see in the United States introduction of incentives so that individuals are paid to be vaccinated in order to increase the level of vaccination. Obviously, the alternative here is to use direct regulation and to have laws which simply require vaccination and do not allow the individual to choose whether they wish to be vaccinated or not. This is, that is the extreme alternative to a market approach to this problem. Okay. Right. Now, I might be moving next to talk about electricity. Actually, the detail of responding to climate change in Australia actually turns on the design of rules relating to the electricity market. Now, this is an incredibly complicated area of law. It's found broadly in what we call our national electricity law and rules. And I have, to some extent, studied this in relation to Indonesia also. So, just looking at the Australian response to climate change, a key part of this is to pass laws and rules which will seek to make a transition in the electricity sector. And at present, you can see that in the last 12 months, we in Australia have had approximately nearly 80% or 70% of our electricity coming from the fossil fuel sector, so coal in particular. Here you can see coal, all right? So that's a problem. Now, one of the points though is in Australian public policy, if we look at the history of the carbon price, Australia passed legislation in the year 2011 to enact the Clean Energy Act. This introduced a carbon price initially in the form of a fixed price or a carbon tax, as Indonesia is planning to do. And you can see here that the result, this is an empirical observation. The black line here is showing you a reduction in generation from the coal-fired power stations, both brown-colored coal and black coal. Now, at this point here, this is where the carbon price legislation was repealed. The political conservatives took control of the parliament in Australia and enacted a law to abolish the carbon price. And the result then was that the emissions and generation from black coal at least, and also brown coal increased. So you can see the result of the interaction of law and politics in this slide. All right, now this slide is showing you the complicated summary of both the targets for climate change response and also the legislation for incentivizes to set targets for renewable electricity, so clean electricity, Listric. Okay, the main point in the top left-hand corner here is that the federal renewable energy target has now been met. So in effect, there is no additional incentive being exerted by that legislation. And as far as a zero emissions target, there is no target in place. So there's a real problem with our national level climate change law. There are climate change laws nationally, but they do not set a target. And broadly, at the subnational level, there has been climate change response laws enacted. All right, one of these is in the state of Victoria, and it's just showing you that they have set at this level a net zero target. And it contains timetables. This is very similar to climate change legislation in Europe. So if we look in France, and France is interesting also from the point of view of climate change law, because the French law speaks about, it actually uses the terminology of climate emergency. It talks about cas d'urgence. Okay, so this is, you see here, pour répondre à l'urgence écologique et climatique, to respond to the ecological and climatic emergency. So the French legislation is interesting because it uses this terminology of a climate change emergency, whereas other laws have tended to avoid that approach. Much earlier, the Danish passed a more aggressive or ambitious climate change legislation, a 70% reduction target by 2030, so a more rapid target. And so, you know, in terms of the parallels between coronavirus and climate change, it's really about what curve would be like in terms of the numbers. You know, what is the curve that we're looking to see in terms of cases of coronavirus, in terms of hospital admissions, in terms of vaccinations. So each nation is setting some targets in relation to that. But my area of expertise is in terms of climate change law. So that's why I'm talking about this. And so the Danish also, in their climate law, speak about climate change being a global problem. But this is the point, that they talk about the responsibility of their nation to lead. Now, obviously, nationally, at our national level in Australia, Australia is not so much leading in terms of climate change. All right, but we certainly have a lot of action at the subnational level. Okay, now I'm seeking to get back here. The Germans, again, they have passed, and maybe Stefan will have some commentary on this, but certainly there has been more ambition in Germany to enact more and more aggressive or ambitious climate targets. Okay, and interestingly, the German legislation in Section 3 introduces what we would call a no regression principle, or no backsliding. So we cannot go back from a target. We can increase the ambition of the target, but we cannot reduce the target. So this is something that we can take from Germany, which is interestingly, in many ways, an implementation of the Paris Agreement and its principles for response to climate change. So the reason why I'm mentioning this in relation to Indonesia is that because I understand Indonesia is seeking to introduce climate legislation, and there will be a national debate about how should that climate legislation look. So there are ideas from other countries in the world, both near to Indonesia and also in Europe, about how to respond to climate change through legislation. Okay, now coming to Indonesia, we have a couple of examples here of, again, more signs of action and response to climate change. The plan to exit from coal. And, you know, I would welcome this. Australia perhaps has not even taken the same step in terms of saying that these coal electricity stations would not be permitted. However, the market, the free market of the electricity industry, they just are unwilling to invest in coal-fired electricity at this point. And this is one of the public policy differences between Indonesia and Australia and its electricity law, is that the Indonesian system still has a state-owned enterprise, and Australia has more of a free market approach to the electricity sector. And so we have a competitive generation market where companies compete to provide the cheapest electricity in accordance with the national law. Now, so that is one aspect of this. The second part is a question of the role of the private sector in providing finance for the clean energy transition. I believe this is a key point. Government agencies can assist to provide perhaps concessional finance for energy transition. This is something that we have in Australia through our Clean Energy Finance Corporation. But this is a welcome sign that solar energy in Indonesia hopefully at some point will become closer to being a consumer item that then gets widespread public adoption. All right, so I believe I may be out of time very soon. So I just wanted to make a couple of quick points about what is happening in the clean energy sector in Australia. There has in the past, in the recent past, been a boom, an increase in investment in clean energy, particularly in wind power and solar power stations. So you can see from this slide, 52 large-scale solar farms under construction at the end of the year 2020. And many of large-scale solar farms being installed in Australia. Now, in Indonesia, perhaps with less available land area, it will be necessary to look at how can installation of solar equipment on buildings be encouraged and incentivized. So Australia has a long history of encouraging rooftop solar on buildings, and perhaps there's much that Indonesia could learn from Australia in relation to this. I was discussing the situation in Indonesia with Fendi Liem, who is a friend and in contact in the renewable energy industry in Indonesia. He says that the industry in Indonesia are not so much looking for a generous feed-in tariff, but they are looking just for to be paid for each unit of electricity that is supplied into the network.
My apologies, sir.
Yeah, we are sedikit. I just very quickly. So one of the key points about our law is to look at how the network companies respond to the generators. And we in Australia need perhaps to take the lead from Germany, because the Germans for some time have had a strong law to encourage or to require the network operators to connect the generators of clean energy. Currently in Australia, though, there's a big problem, a policy problem of difficulty to connect to the grid and difficulty for generators being constrained in their production of clean energy. So if we look at the national electricity laws in each country, that is an important area for reform to encourage clean energy, and we must reform actual electricity law to do this. Australia's electricity law does not include an environmental objective, and I would argue that if we look at the English or German examples of electricity law, we need to include an environmental objective into an environmental protection objective inside the electricity law. Okay, and finally, just in Australia, we have debate over a sun tax. Now, this raises questions of social justice. So this question in the energy transition in Australia has concerned whether individual householders and businesses should be now charged to export electricity to the network. And this raises a lot of questions about the social allocation of costs and benefits. And this is a very complicated policy problem, but it needs clear and consistent leadership by governments, and it needs that response needs to examine the experience of countries which have already considered these questions. Okay, so this is my last point, and if I can start to just draw one or two conclusions, please, and then I will be finished. So, broadly, I've made the proposition that the similarity between climate change and the response to the coronavirus crisis is that both of these problems are collective action problems. They're global problems. They require strong leadership by governments that is based on science, and they need to take account of the economic drivers of behavior. So the fact that individuals and companies do respond to economic price signals, and they also respond to clear and consistent legislation and the enforcement of that legislation. So there is a role for the law to respond to these problems, but obviously in enacting any law, there are questions of the allocation of costs and benefits. So terima kasih banyak. That's it.
Thank you very much, Sir Dr. James Press, for giving a new insight of climate change, and that our problem is not only just how to take care of coronavirus pandemic, but also we have another problem like climate change. Now we come to the Q&A session. We're going to have a discussion and a question and answer session, and therefore I'm going to read some of the questions on the chat. There are some questions, sir, on the chat that is directed to the speakers here. So the first question is from Tati Nurul Alsina. She asked questions for all the speakers about what do you think about the spread of COVID-19 in the world? Can this case be an obstacle in the development of countries, especially in the development of law? Yeah, that is the first question. If I may read the other questions first, or you may answer the questions, because there are some other questions first. Or
maybe one by one.
One by one. Yep.
Sure.
So
that's the first question, sir, about what do you think about the spread of COVID-19 in the world? Can this case be an obstacle in the development of countries, especially in the development of law? And probably I'll give an addition, development of social justice, because you see here there's Prof. Kim Jun Kim from Social Justice Department. Yeah, sir. Time is yours, sir. Maybe from Professor Stephen first, or yeah.
Okay, I was muted, sorry. Yes, the answer would be very complex, so I will make it, of course, fast. Yes, indeed, I think this COVID-19 pandemic has an impact on various aspects of this. One aspect was part of my presentation. It leads to a stronger and faster digitalization, which is indeed, in my opinion, in a way hindering the development of the law as a social conducting instrument. On the other side, we have also other aspects like closing of the borders, very important. The mistrust against international institutions already was before, and is, in my opinion, in this time grown. The mutual mistrust between nations, also very important, and also national egoism and this protection aspect of the government. So this rhetoricization aspect is leading to and hindering for the development of the international law, in my opinion. On the other side, it could be also an incentive to it. We cannot know it now. So we heard of my colleague from Korea that he thinks that the pandemic was improving the solidarity between the people, and my view in Germany is exactly the contrary. It is, in my opinion, making it worse. So yeah, the pandemic is hindering, but on the other side, an incentive to find new ways. And these new ways, if they are legislative, are of course a question of developing the law. And we need new law for that. So we have now, for example, just one example, we have this data protection aspect with the Zoom meetings and so on and so on. So on the level of the national law, we are now thinking new the data protection law. Maybe in 5 years, we will have a more pragmatic data protection law, whether that is good or not, but this is a development of the law given us because of the pandemic.
Thank you, sir.
Yes, I also respond to Nurul Fina Husdi's question, and I would like to combine it with Bimo Satrio Wibowo's question. And I think the pandemic teaches us that there is a big difference between individual freedom and government control. And as Professor Stefan said before in Germany, yeah, that these conflict has been escalated to the extent that the individuals, the citizens, yeah, opposed to the government control or policy, something like that. So we have to think about whether or not the government have the right to intervene into the right of individuals. And that has been the question we have been talking about quite long, but the pandemic situation have given a new dimension. So we are talking about much more stronger regulation of the government. And it is definitely dangerous, especially I think in Southeast Asia, where the government tried to strengthening their power against the society. So we have some dangerous, we are under the dangerous situation. But still, I believe that the only way that we can react, we can respond properly is some collective measures of citizens based on, I think, consensus. So in that sense, the government can promote some sort of communal associations or communal meetings or deliberations or something like that in order to promote the sense of community, sense of solidarity, which may work as to support the government regulations, at the same time control the tendency of the government to strengthening their power. Yeah, it is in some sense what I said was somewhat idealistic, but still we can feel that under the pandemic, we are connected. For example, in Korea, we Koreans feel that we are connected. And in terms of world, we are connected to India or China. So I think in that sort of sense of connectedness, if it can be used, it can be promoted properly, I think it can bring about a good environment to fight against the pandemic on the one hand, and on the other hand, we can find out new ways to think about our neighbors, our communities, and our international community. So in that sense, I think there is some danger that we give power to the government to carry out some collective works. But at the same time, if it is inevitable, we have to find out ways to control the government policies, to control that their power does not go to the way to strengthening the autocratic power of the government. Yes.
May I just ask may I just add something to that, which is, I think this is a very important aspect, what I learned. And this is also important for Indonesia. In Indonesia, we discuss much about CSR, corporate social responsibility. And there is legislation in India and Indonesia about that, which is not given legal incentives, that there is penalty if you're not social responsible. So how we make incentive for social responsibility? In the pandemic, we talk all about solidarity. And what I learned from the pandemic, and this is I presented that in Kuala Lumpur, we discussed that very much, is that we cannot force solidarity. So the law cannot force solidarity. We cannot say we must be solidaric, and that is why in a contractual situation, one part does not get the money and the other part can keep the money. Yeah, this is not possible. So if we want to develop the law in a proper way, and we can learn from that, this is a lesson from this. Then we should think more in the legal research on risk allocations, which is more or less a thing from the economy. Yeah, so we must combine more the interdisciplinarity with the economy and think more about risk allocations, which my colleagues in the civil law often not do. Yeah, we talk about contractual situation, mutual trust, and then this. But there must be an allocation by the state. If we see the force majeure things, these force majeure things in the time before the pandemic, we could handle that. But in the pandemic, we see that the rules of the force majeure, which are developed by the civil law, in my opinion, not working properly. So we must develop that. And this is, for me, the most important lesson I took from the pandemic time and from the discussions on that.
Thank you, Sir Professor Kus and Professor Kim. Maybe from Dr. James Press, you want to give some additional information about the question on how this COVID-19 is actually impacting the climate change, or on how actually the climate change has been altered by the lockdown policy or something other. Because the issue in Indonesia, we know that some people say that the lockdown is actually good for environment. We can see how the air somehow is get any particles. We don't have any things that give more burden to the air pollution. But now we can see now from your explanation that we also face a climate change issue. Dr. Kemp.
Yeah, thank you. Yeah. Well, clearly, if there's less transport activity occurring, there's less fossil fuel being burnt, there's less air pollution, etc. But this is just a temporary reduction in pollution. And my recommendation to governments would be that they should use this opportunity. Number one, the need to stimulate the economy after the economic contraction, but to spend that economic stimulus rather than just giving the citizens cash money to spend on, beer and cigarettes, but instead to spend the money in research into solving social problems. So health research, health technology, and clean energy technology, and other types of public goods. Education is a public good, so there shouldn't be cuts to universities at this point. But in Australia, we have the opposite occurring. We have cuts to university funding. So I would be saying that where you have what economists describe as a public good, in other words, some type of community investment, roads, infrastructure, internet technology, telecommunications, clean energy technology, clean transport technology, all of this investment can be an opportunity to encourage a response to the coronavirus situation, which will lead to a long-term reduction in pollution, but also economic welfare, health outcomes, social outcomes. So, but the problem here is that I think still that in some countries and some parts of some countries, we only have a response to a crisis if people believe that it is a crisis. So, you know, the problem with climate change and also the coronavirus is that there are sections of the population who do not believe that the problem exists, or they deny that the virus exists. They deny that climate change exists. So this is where if we take too much of an excessively American libertarian approach to freedom of the individual, we will allow society to be governed by uneducated people rather than to allow society to be led by governments who are informed by the best available science. So it's very important that science has a role in making, I'm not saying that society should be run by technocrats or lawyers, but that the lawmaking should take account of the best available science, and that politicians should listen to the scientists rather than to listen to their political constituency. Thank you.
Thank you. That's also a very big issue here in Indonesia. Especially we are divided into some society who believe on coronavirus, who believe on climate change, and who do not believe that. And there are also some conspirational theory, conspirational theory about this COVID.
Can I say one thing about this? When you speak to the scientists about is climate change a matter of belief, or is coronavirus a matter of belief? It's, you know, it's like saying, do I believe that my my handphone exists, or does this pen exist? You know, it's not a matter of debate or belief. It's just this thing is here. It exists. You know, so the scientists are telling us that the pen exists. It's a pen. So what should we do with the pen?
Oh yeah. So yeah.
So it's like saying
in the philosophy there may be other approaches, but basically you're totally right, of course.
I mean,
I'd like to add one dimension to James' argument, that I think we need some sort of medium to translate scientist language into ordinary people's language. I think that that's a weak point of the scientist. So they are saying you have to believe, but we have data, something like that, scientific data, something like that, but still it is less accessible to ordinary persons to believe or to understand what is taught, what is conveyed by the science.
I think it's not a question of the capacity. I think it's a question of the wish to listen to it, because many of these causal conjunctions are good, understandable for the people, even for if you're not a scientist. But if you discuss with these people, they just switch off their mind and follow certain rules. It is not logical to follow someone in the YouTube who has no experience and no idea about the things, rather than to follow a logical causality which is given by the science. This is not logical, and you will not, I think you will not be able to approach these people by translating it to a simpler language, even more simple than it is already, in my opinion. This is my experience from Germany. I read a lot about these conspiracy things. If you discuss about that masks make you sick rather than corona makes you sick if you don't wear a mask, what you want to discuss here? We have this question here in the chat also. Mask is harming or not? Yeah. So how easy it should be to put something in front of the mouth and the nose, which is filtering virus. Why it should not help? But logically, it's not logical to follow someone who says in the YouTube, wear the mask and then you will suffocate from it.
Yeah, but because of that, we still need some medias, languages that we can communicate with them. For example, we just give up. They have some sort of prejudice, which is illogical, and that we can't do anything for them. I think that might exacerbate the situation. So even if, of course, I know it's baseless, but still we need to find out ways to communicate what is logical, rational, and what is illogical and irrational in their terms. I think it still needs.
Yep. Can I raise one point in relation to this, which is about the role of Parliament or government in making laws to control misinformation. And so we have social networks and some news media outlets that are deliberately spreading misinformation. And so there's a real legal question about to what extent should we restrict the spread of misinformation. So we've seen recently that YouTube in Australia has blocked the network Sky News from YouTube temporarily for 7 days in its first warning because it was spreading misinformation about the coronavirus. So it is important that, you know, it is possible to control the spread of this misinformation by not giving a platform to it, and to make a clear rule that you cannot spread misleading information about a particular topic, or to be deliberately misleading. So it is possible, and there's an important role for scientists and the public broadcaster to do fact checking. So if a politician or some other popular figure makes a statement about something, then this can be fact checked by scientists, and then the response to the claim can be published so that citizens can inform themselves about whether a claim made by a politician is misleading or untrue, or whether it is in some respect factually correct. Thank you.
Thank you very much. Thank you very much, Professor Kun, Professor Lim Jun Kim, and Dr. James Pratt. I think we are about to come to an end because we have 4 minutes left. If you don't mind, I think it was a very great discussion and opportunity for us to have you in this international conference, considering the factual and contextual issue, as well as a novel issue about the technology, the climate change, as well as the idea of justice on spreading the subsidy. And therefore, I do apologize that there are some questions we cannot address for now. For now, we're going to just wrap or conclude on our afternoon that we live in the same earth and we share the same burden right now as we understand, and that therefore it is an obligation to preserve the humanity and preserve environment to get along into the future. And therefore, I think it ends our first panel session.
May I just give a short suggestion to you? This discussion I liked very much. This is the first time since long in conferences in Indonesia that we could discuss the speakers to each other and with each other, and not just present and have questioning and answering. So my suggestion would be, it's not as criticism, it's just for maybe for the future. Maybe you can make something conference like this and make podium discussion about these topics, because this is something we use here very often, and I think it's very fruitful to exchange between the speakers and not just stand there, talk 30 minutes, especially in the Zoom time, yeah, talk 20 minutes in front of the monolith of a computer and then just be questioned. So this is just a suggestion for the future, because I really like this.
Yeah, thank you, sir.
Genau.
My biggest apology from the committee that we cannot provide enough time to discuss this. Maybe later we can provide longer or maybe such kind of a lecturing program, perhaps. Dean of Faculty of Law probably like to help this kind of lecturing, because this is exactly very interesting. Every single session of this discussion is very interesting and a very new insight for us. So thank you very much for the suggestions. Now, because we only have several minutes left, we're going to give some awards for the speakers for attending today and for providing time to meet us today. This award is a certificate award as an appreciation and gratitude from us, the committee, to each of the presenters, of the speaker, for giving a very grateful insight today. Now, for the first award, we'd like to give to Professor Dr. Akun for giving an extraordinary thorough information about the digitalization and the and COVID-19 and technology. So the first award, the committee, would you like to give the screen of the award, please? The committee?
Terima kasih banyak.
Yep.
Yeah.
Terima kasih.
Here.
Terima kasih, Prof.
Now,
Terima kasih.
Dengan senang
the
hati.
second award.
Terima kasih, Prof. Stefan. Terima kasih, Dr. James. Terima kasih, Prof. Kim.
Yeah. Now the second award would like to give to Professor Hyun-Jun Kim.
Yep. Terima kasih banyak. Yep.
Terima kasih banyak.
Yeah, sama-sama Professor and Doctor. Thank you very much for coming virtually today. This is a very great opportunity, and we are very delighted to invite. And this is the end of our session. I would like to say session, and I hope that we can meet again on another occasion. Thank you very much, and wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Terima kasih.
I give the time to the Master of Ceremony back. Thank you.
Can we share the materials in the chat to the participants?
Yes, sir. Please, if you would like to share on the chat, it's very helpful.
Unfortunately, I cannot do it here. Maybe you share it from the committee to the registered participants.
Oh, sure. The last part.
Yes, because I cannot send here. Okay. Thank you.
You are welcome. Thank you very much. Good afternoon in Bertha time or in Germany time. I think it's still in the morning in Germany.
Very much in the morning. It's 7:15.
Oh my
Thank
God,
you, dear colleagues. It was a pleasure to meet you.
Yeah, you've been here from 8:30.
Thank you.
I believe it was midnight.
It was 3 o'clock when my alarm rang.
Oh my God! Well, thank you very much for giving.
No problem. Tomorrow I have the same at 3 o'clock in the morning. It's always in Indonesia like this.
Yeah. That's
Okay. Thank you very much.
Thank you very much.
It was a pleasure.
for the master of ceremony.
Ladies and gentlemen, we have followed with the first panel session. Once again, we would like to thank you for the speakers and moderator and the participant of international conference. Thank you for your attention and cooperation.
Before we continue our second panel session, we invite the audience to enjoy a 30-minute time break. We will start our agenda on the second panel session by presenting 3 other speakers at 1 p.m. Accompanying the time break, ladies and gentlemen, let us present an acoustic music performance from Mabes Music Project. We invite.
UAD. 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 UAD.
Okay, hello everyone. Back again with our Mabes Music Project. Okay, maybe in my first session, it was just the 2 of us now. We have additional personnel. Let me know in Kajon there is Jamil, and the bassist there is Haikal. Okay. So, this song was titled Kasih Putih by Glenn Fredly. Terdalam yang pernah ku rasa, hasratku hanyalah untukmu, terukir manis dalam relungku. Jiwamu, jiwaku menyatu, biarkanlah ku rasakan hangatnya sentuhan kasihmu. Bawa daku, penuhiku, berilah diriku kasih putih di hatiku. Ku curahkan isi jiwaku, hanyutkan daku dalam air hidup. Kau bawa samanya diriku, biarkanlah ku rasakan hangatnya sentuhan kasihmu. Bawa daku, penuhiku, berilah diriku kasih putih di hatiku. Ku rasakan hangatnya sentuhan kasihmu. Bawa daku, penuhiku, berilah diriku kasih putih di hatiku. Biarkanlah ku rasakan hangatnya sentuhan kasihmu. Bawa daku, penuhiku, berilah diriku kasih putih di hatiku. Okay, thank you very much for your attention. And so the song was titled Kasih Putih by Glenn Fredly. Okay, the next song. Okay, the next song.
Cek.
Okay, for everyone who knows the song, can I sing along with me?
Been reading books of old, the legends are the myths. Achilles on his gold, Hercules on his gifts, Spider-Man's control, and Batman with his fist. And greedy, I don't see myself upon the list. Sister, where you wanna go? How much you wanna risk? I'm not looking for somebody with some superhuman gift, some superhero, some fairy tale face. Just something I can turn to, somebody I can kiss. I want something just like this. Do 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 do. Oh, I want something just like this. Do 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 do. Oh, I want something just like this. I want something just like this. Been reading books of old, till I inside a maze. The tales when they told, Talmud and his claves, and Superman unrolls a shoe before he leaves. But I'm not the kind of person that he faced. Sister, where you wanna go? How much you wanna raise? I'm not looking for somebody with some superhuman gift, some superhero, some fairy tale base. Just something I can turn to, somebody I can miss. I want something just like this. Do 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 do. Oh, I want something just like this. Do 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 do. Oh, I want something just like this. I want something just like this. Where you wanna go? How much you wanna risk? I'm not looking for somebody with some superhuman gift, some superhero, some fairy tale beast. Just something I can turn to, somebody I can miss. I want something just like this. Do 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 do. Oh, I want something just like this. Do 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 do. Oh, I want something just like this. I want something just like this. Okay, thank you. So the song was titled Something Just Like This by the Chainsmokers. Okay, once again, thank you very much for Ahmad Dahlan University and Law Faculty for giving us the opportunity to make music here. Okay, the last song will be All I Want by Kota. For everyone who knows the song can be sing along with me. Okay, let's go. All I want is nothing more, to hear you knocking at my door. 'Cause if I could see your face once more, I could die a happy man, I'm sure. When you say your last goodbye, I died a little bit inside. I lay in tears in bed all night, alone without you by my side. But if you love me, why'd you leave me? Take my body, take my body. All I want is, and all I need is, to find somebody, I'll find somebody like you. So you brought out the best of me, part of me I've never seen. You took myself and wiped it clean. Your love was mine for movie screen. But if you love me, why'd you leave me? Take my body, take my body. All I want is, and all I need is, to find somebody, I find somebody like you. All I want is nothing more. Okay, thank you so much.
attention please to ladies and gentlemen of the audience of the participant. Soon, we will start the second panel session. Please allow us to rejoin the media Zoom meeting and please be prepared to the second panel session. Ladies and gentlemen, in the second panel session, 3 speakers will present. Professor Dr. Estrella Arroyo from University of Saint Anthony, Philippines, Dr. Rohana Abdurrahman from University Utara Malaysia, and Dr. Normasari SHM Hum from Universitas Ahmad Dahlan. We will Mrs. Dr. Ani Susanti, SPD MPDBI, to guide the second panel session.
Please allow us to read a brief CV for our moderator in this second panel session. Ms. Dr. Ani Susanti, SPD MPDBI. She is a lecturer at the Faculty of Teaching and Education, Universitas Ahmad Dahlan. She undergraduate and postgraduate at Universitas Ahmad Dahlan, and she has completed her doctoral at the Universitas Negeri Malang in 2020, which the field of English education. She has written several national and international journals, and she is currently active in various international and national organizations. Then we invite Ms. Dr. Ani Susanti, SPD MPDBI, to guide the second panel session. We invite you.
Thank you very much for the Master of Ceremony. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Thank you for here with us for attending the second panel sessions in the Conference of Ahmad Dahlan, International Conference on Law and Social Justice. In these sessions, we are going to have 3 great speakers who are here with us. The first is Professor Dr. Estrella Arroyo from University of Saint Anthony, Philippines, who is going to present the forthcoming access to education, learning from the present pandemic. And the second presenter will be Dr. Rohana Abdurrahman from University Utara Malaysia, with the topic of mediations and pandemic revolutions. And the third, we have Dr. Normasari SHM Hum from Universitas Ahmad Dahlan, who is going to talk about health consumer protections during the COVID-19 pandemic. Ladies and gentlemen, we would like to inform you that each speaker will present about 20 minutes, and later we will open question and answer sessions for about 30 minutes. For all the participants, please feel free to either note your questions in the chat box or raise your hand during the question and answer session. When the panelists are doing their presentations, please be advised to have your microphone off and your camera on. Okay, ladies and gentlemen, education should be the most and basic pillar of civilizations. However, since the spread of COVID-19 outbreak in the early of 2020, education becomes one of the biggest sectors affected by the pandemic. To avoid the spread of the virus, everyone shall implement physical distancing protocol, resulting in the obligation on physical media of education. To address this issue, we would like to have Professor Estrella Arroyo, Doctor of Education, and also the Dean in the College of Liberal Arts from the University of Saint Anthony. She receives the Doctor of Education degree in Filipino language and literature, and she is currently working as multimedia practitioner, textbook writer, academic researcher, and also senior lecturer. Professor Arroyo, the screen is yours.
Dr. Moklas, Rector of the Universitas Ahmad Dahlan, Dean Nugroho of the Faculty of Law, faculty speakers, and virtual participants in this first Ahmad Dahlan International Conference on Law and Social Justice. Selamat siang Indonesia, magandang hapon Philippines, good afternoon, good evening world. Saya sangat senang bisa kembali bersama Komunitas UAD. I am very happy to be with you, UAD community. My topic is the forthcoming access to education, learning from present pandemic. As academician for more than 30 years now, I anchor my discussion and connect to environment and social responsibility and how we should look into the future of education. The impact of the pandemic on law and justice, human rights, public and private education, public health, public governance, biodiversity laws, climate change and economic growth and development is incalculable, both the national and global welfare index of man. But the bottom line is that all these underlying issues impinge on education and provide us opportunities to readjust, refashion, reorient, reprioritize, and re-engineer the educational system to be responsive to calamities like the pandemic that is still wreaking havoc to nations and communities around the world. Education's reason for being is not to train workforce of today, tomorrow, or yesterday, but to enable human flourishing. So states Stavros Yanuka in his piece titled Building the Future of Education in a Post-Pandemic World in the Diplomatic Warrior. He continues, at its core, a good education should be about gaining and continuously updating our understanding of four things: consciousness, civilization, ecology, and the cosmology that envelops them. The first topic I would like to discuss is consciousness, the state of being awake and aware of one's surroundings, especially now COVID-19 has disturbed our relationships within our milieu. Education was deeply hurt by the pandemic, and we in this education sector are still in the process of healing these damages in the curricula, in the delivery of service, and in the manners of assessment. Education is the first to be disrupted, but the last to have restarted. The big challenge is how to showcase the content that meets the sensibility of students' learning, and how we realign our curricula to modalities, as well as the preparedness of both teachers and learners. Teachers cannot be replaced by technology. So, teachers' well-being should be, foremost, be protected. Legislations and policies promulgated by the government should take care of the interests of teachers. Awareness campaign, especially on environment issues, must be emphasized because of the importance of the learning environment, both literally and figuratively. Secondly, I wish to discuss a bit the role of civilization in education. In an article written by Stefania Giannini, Assistant Director General for Education of UNESCO, and John Brandalino, Division for Treaty Affairs Director of United Nations Office of Drugs and Crime, titled COVID-19, Education is the Bedrock of a Just Society in the Post-COVID World, stresses the importance of education, which teaches awareness of human rights and ultimately helps build more equal, sustainable, and inclusive societies and economies that are more resilient in the face of crisis. UN Secretary General Antonio Guterres, in his April 2020 report, said, "The economic and social crisis is fast becoming a human rights crisis, and that any emergency measure taken must be legal, necessary for protection, proportionate, and discriminatory. Education is the key ally in defending rights and protecting the rule of law, and is an essential life skill in crisis. How can you protect your rights when you do not even know what they are? Learning empathy, respecting diversity, and being able to recognize and challenge discrimination are key skills that young people should know. A crisis management turns to addressing future educational challenges, which UNESCO and UNODC are working to place rights at the center of education by helping countries deliver educational programs that empower children and youth, especially girls and most vulnerable groups, to understand and exercise their rights, to build bridges between change makers in the education and justice sectors by providing policy guidance for policymakers and share effective strategies and innovative practices to institutionalize education for justice within educational policies, curricula, and school governance. And to support teachers by equipping resources in order to teach children about their rights and structural factors that cause inequality, and to empower them to become engaged citizens who build just societies to the future. The third topic to consider is the role of ecosystems in the management of COVID-19. The rising international concern about zoonotic origins of many global pandemics and the increased human-animal interactions emphasize the close relationships between human, animal, and environmental health. Contemporary livelihood and market patterns tend to degrade ecosystems and their services, driving a cycle of degradation in increasingly tightly linked socio-ecological systems. Human activities driving this degrading cycle tend to convert beneficial ecosystem services into disservices, exacerbating risks related to zoonotic diseases. Conversely, measures to protect or ecosystems constitute investment in foundational capital, enhancing their capacities to provide for greater human security and opportunity. And the fourth topic is cosmology of coronavirus. Dr. Ephraim Morgan discusses how COVID-19 intertwines with our existence in the cosmos, how we can process through this. Cosmology is how we humans relate to the universe around us and everything that is in the universe in a relational way. COVID-19 has taken over our lives. We have to consider nature not as an enemy to get us. Nature also defines our relations with other people. People help people to walk through this COVID-19 related illnesses. Let us all walk together through this. The COVID-19 pandemic has distracted the world, especially in the field of education. Billions of learners have been out of schools, while others struggle to transition by using different strategies as the world is suffering multiple crises like climate change, political instability, economic swings, and health challenges. There should be an approach to connecting community resources that are adaptable, sustainable, and equitable. There must be a way to democratize connectedness so that students and educators could more equitably access the social, intellectual, creative, and cultural capital of their community. People are looking for more holistic, adaptable solutions that can support learning in multiple contexts. If we are going to address the root causes of the systemic issues we face today in education and beyond, we need a narrative of change. We must become the stewards of our own narrative and the collective narrative we want to create in the world. This requires that we not only shift our own mindsets, but also create opportunities for everyone in the community to see that each of us has unique gifts and lived experiences that are essential in creating resistant, vibrant learning ecosystems and communities. All the preoccupations of man, from the mundane to the profound, all the ugliness and beauty that he undergoes in the saga of living are going to naught if he deliberately forgets or mistreats the blue planet that nourishes him as a super animal above the rest of the animal kingdom. Education must always factor the role of the planet Earth it plays in the life of man from the beginning of human civilization to the present. In all of the entire life of Homo sapiens in this century, the inalienable presence of education defines the trajectory of life as his civilization is refined century by century. A well-known visionary scholar, author and professor Nicholas Negroponte, founder of the Massachusetts Institute of Technology Media Lab, pointed out the indivisibility of education in the rise of man's civilization. He says, no matter what global problem you are dreading, whether it is the elimination of poverty, whether it is solving environmental energy problems, the solution, whatever it is, multiple solutions, the solutions always include education. Never it is without an education component, and sometimes cannot be done without education. Education per se is the shining jewel in the solution to the problems of man, like the pandemic that disrupted, altered, and destroyed the many institutions that man built through the ages. The traditional idea of a society and governance, the church, the schools, and the family had been torn apart by the rapacity of COVID-19. Our consciousness of traditional society had also changed. The tenets of rugged individualism must now give way to collectivism and community for man to survive. To survive, we must adopt the Bible's edict that we are indeed our brothers and sisters keepers. We can never be an island or be indifferent with our neighbors, our fellow men, and the community we live in. The guiding post for us to survive and prevail is to love and care for each other. The pandemic teaches us that every human being on planet Earth are interdependent and interconnected, that preserving that umbilical cord of sense of kinship and belonging is our insurance to survival in this unpredictable, manipulated economic world system. Carl Sagan, the American cosmologist and astrophysicist, echoed that sentiment more than 25 years ago when the images of Mother Earth taken by Voyager 1 space probe in 1990. From Goodreads, his classic quotes remain forceful. Look again at that dot. That's here, that's home, that's us. On it, everyone you love, everyone you know, everyone you ever heard of, every human being who ever was lived out their lives. The aggregate of our joy and suffering, thousands of confident religions, ideologies, and economic doctrines, every hunter and forager, every hero and coward, every creator and destroyer of civilization, every king and peasant, every young couple in love, every mother and father, hopeful child, inventor and explorer, every teacher of morals, every corrupt politician, every superstar, every supreme leader, every saint and sinner in the history of our species lived there on a mote of dust suspended in a sunbeam. And he continues to say, the earth is a very small stage in a vast cosmic arena. Think of the rivers of blood spilled by all those generals and emperors so that in glory and triumph, they could become the momentary masters of a fraction of a dot. Think of the endless cruelties visited by the inhabitants of one corner of this pixel on the scarcely distinguishable inhabitants of some other corner. How frequent their misunderstandings, how eager they are to kill one another, how fervent their hatreds. Our posturings, our imagined self-importance, the delusion that we have some privileged position in the universe are challenged by this point of pale light. Our planet is a lonely speck in the great enveloping cosmic dark. In our obscurity, in all its vastness, there is no hint that help will come from elsewhere to save us from ourselves. The Earth is the only world known so far to harbor life. There is nowhere else, at least in the near future, to which our species could migrate. Visit? Yes. Settle? Oh, no, not yet. Like it or not, for the moment, the Earth is where we make our stand. Further, he states, it has been said that astronomy is a humbling and character-building experience. There is perhaps no better demonstration of the folly of human conceits than this distant image of our tiny world. To me, it underscores our responsibility to deal more kindly with one another and to preserve and cherish the pale blue dot, the only home we have ever known. The pandemic has taught us lessons: resilience, creativity, ingenuity, and spirit of cooperation. We are also confronted by realities as well as possibilities to attain social justice and equality. Technology is not sufficient to sustain education. It is still the human heart that the quality of life, the wake-up call to many realizations of truth and facts. What, then, is the future of education that must be refashioned from the lessons of the pandemic? The educational system, the world over, is supposed to be the social leveler as it provides opportunities for everyone, regardless of economic station in life. But that is not the case, owing to the disparity in growth and development of the 195 countries of the world and the impact of technology in their respective economies. Good afternoon, everyone. Thank you so much. Terima kasih.
Thank you very much for Professor Arroyo. Now let's move to the next panel, living in the middle of society as a zone politicon. Having dispute is something unavoidable. But dispute does not necessarily mean the parties are in a referee situation. We have an alternative dispute resolution like mediations. Mediation has become a nearly ideal way to settle any dispute. However, COVID-19 pandemic changed the culture of mediations as we have to reduce the physical contact. Dr. Rohana is going to address this issue. Dr. Rohana Abdul Rahman is an associate professor at UUM School of Law. She obtained her LLB degree from International Islamic University Malaysia in 1993, LLM Business Law from University of Wales, United Kingdom in 1997, and PhD in Law from the University of Queensland, Australia in 2013. She is a qualified advocate and also a solicitor. She started her career as a practicing lawyer in 1995 in Kedah, and she joined University Utara Malaysia as a law lecturer at the School of Management. Dr. Hana has held various administrative positions at the university, including coordinator of LLB program, head Department of Law, deputy director for distant learning program, and director of Asian Research Institute for Corruptions. Currently, she is the Dean of School of Law in UUM, and Dr. Rohana teaches company law and professional practice courses at the undergraduate level and has supervised postgraduate master and PhD students at the university. Her area of supervisions include government procurement, anti-corruption law, insolvency law, alternative dispute resolutions, and commercial law. Ladies and gentlemen, please welcome Dr. Rohana.
Terima kasih Ibu Anisanti. Can you hear me?
Yes, quite clear.
Quite clear. It's good. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and selamat siang. Today to everybody. Yang berbahagia Dr. Mukhlas, the Rector of UAD, yang sangat saya hormati Bapak Rahmat Muhajir Nugroho, the Dean of the Faculty of Law, UAD, fellow speakers, Professor Arroyo and Dr. Norma Sari. First and foremost, I would like to thank you, the organizer, for inviting me to join this auspicious international conference organized by the Faculty of Law, UAD. First, I would like to apologize for changing my topic. Actually, I think the original topic was arbitration and pandemic revolution, but I asked Dr. Wita and informed Bapak Elias that I think I would be more comfortable speaking on mediation and pandemic revolution, right? Oh dear.
Okay, something wrong with the Dr. Rohana? Dr. Rohana is trying to find out. Dr. Rohana is still with us here. Okay, let's wait for some moment, ladies and gentlemen. while waiting for Dr. Rohana, who wants to continue her presentation. Probably we are going to have some talk with, we want to greet Professor Arroyo. Good afternoon, Professor Arroyo.
Good afternoon, Miss Annie, Professor Annie. Good afternoon. I am so happy to be here again.
Yeah, happy to see you here in the same screen talking about law. We usually discuss about education, but then we learn now in another conference of law and social justice. Is everything okay in Philippines?
Yes, but there is now this another surge of COVID-19, and well, it is really scary. You know.
Okay, everyone work from home or from the office?
Oh, there are so many. There are so many workers, who really stay at home, do their business at home, their work from home. But for me, I come to my workplace every day, because I am needed in the office. So there are also some days, when I do not have so much work to do, and I ask permission from our president to allow me to work from home, and he's always willing to do. He allows us, to work from home.
Okay, thank you. We think Dr. Rohana, you back?
Yes. I'm
Okay.
so sorry. I had a blackout at the university just now, and everything just push.
Okay, that's
so
quite
sorry.
common. That's quite common in this pandemic. We need mediation with the system too, with Zoom. Okay.
Sorry about that.
Yeah.
Okay. Can I continue, please?
Yes, please.
All right. Okay. As I was saying, thank you, Prof. Arroyo, for coming in. To before I can come back up. All right. The content of my presentation today is divided into three. That is the current scenario, and then current initiatives relating to mediation, and also the way forward. Just now, we listened to, how pandemic COVID-19 has affected education all the way, throughout the world, how it affects everybody. Nobody's going to school, at least in Malaysia at the moment, and I believe so in a lot of Asian countries. And if you look at the businesses, so this is where mediation is coming in, whereby we see a lot of disputes and problems affecting the business people, and what is the way forward, and how are we going to look at this, whether the alternative dispute resolution, can give an alternative and on how people can actually compromise on certain things rather than go to litigate in the courts. All right. First, as we know, COVID-19, the coronavirus, is our common enemy. We are fighting the common enemy, and I believe in the morning also we have heard a lot on this, on how it affects the society, how it affects people, and I think that there is no case of blaming each other. It's not your fault. It's not my fault. Because it's a common enemy. We are fighting the virus together, every single one of us. So in this very trying time, I believe we need compassion. We need compassion. We need flexibility to be able, to move on and to live together. Facing this coronavirus, and as we know, this is not going to, end soon. We may be living with it for the next couple of years. So we have to find ways and to be compassionate enough, kind enough, towards each other in this very trying time. And I believe this year is I call it the year of vaccines. You know, we see people vaccinating everywhere, and you know, different numbers of people are having vaccines. If you're not vaccinated, you can't fly, or you can't. There are restrictions, you know, things like that. So a lot of countries are going very much faster towards vaccinating all citizens. All right, the current scenario, I would like to look at the these three organs, yeah, of the government. I believe the executives or the governments all around the world are taking steps to address this pandemic COVID-19. And we see a lot of financial stimulus, you know, financial help or packages being rolled out by the governments to help the people. And there has also been a lot of processes of the government transaction and businesses that have been eased up, so that you know, a lot of businesses are not cut off or can proceed in their trading. And as I said just now, we see these vaccination programs being rolled out for the citizens, yeah, in a lot of states. So everybody is trying their best, you know, with handling this issue in their respective portfolio. And on the other hand, the parliament or the legislature are passing laws to address pandemic. We know that the lawmakers are very slow, you know, in coming up with addressing. It is very different from the technologists, you know, people in the computer world. The lawmakers are very slow, you know, taking a lot of precaution to come up with new laws. But when we are being you know, bogged down with this pandemic, the parliament has got to have to be brave enough, you know, to come up with laws in order to address this pandemic. And we see a lot of emergency orders around the world that has been passed by the legislature of each country to order for lockdowns or travel restrictions in order to contain this COVID-19. And we also see laws that have been passed in order to relax the government transaction and businesses to help the economy of each country. And we also see that the courts here, the courts are closed. There's no trial, there's no hearings being done face to face. And because of that, we see a backlog of cases grew, yeah, from day to day. This is happening from last year until this year. At least for Malaysia, the courts are not open, but they have moved on to do the e-courts or the online case management or online hearings, right? So I believe this is happening around the world, throughout the other states also. Right. The effects of this pandemic has continued yet to dominate the world, bringing an elevated level of instability to businesses across various industries. So these uncertainties has triggered the growth of different types of disputes. And because of that, it has greatly influenced the way we solve these disputes. So there's a lot of disputes, and the business people, they want fast and clear-cut ending to whatever disputes that they have. So it's either you go and litigate in the courts, or you go for arbitration, yeah, where you have an order and an award so that it can be endorsed by the courts. But we also must not forget that, as I said just now, being compassionate, being flexible, there is another way under the umbrella of alternative dispute resolution. That is what we call the mediation, where you mediate, you have a mediator, a third party who is not biased, who is independent, but who help the parties, the disputing parties, to find a win-win situation, to find a result that that will satisfy, yeah, both parties along the way without going to court. So we negotiate, we conciliate, or we mediate our disputes yes, to settle our problem responsibly. So by having this out of court initiative, by being compassionate, by being understanding towards each other, so it is hoped that we can achieve fairness and reasonable outcome for the parties concerned. Because as we know, if we go to court, there will be only one party who wins. The other party will go home empty-handed. You know, there's always like that. So in this very trying time, sometimes, like I said just now, we're fighting a common enemy. It is not my problem, or it is not really my fault, because I cannot fulfill my side of the contract. But because the contract term says, if you don't fulfill your side of the contract, the other party can take action against you. So we go to court. So we go to court, the other party definitely will win, because I was the one who failed to fulfill my side of the contract. But if you go for a mediation, then we have to come with, you know, I come with my problem, you come with your demands, and we try to meet halfway. So in that sense, you understand my problem. It is not really my fault. And I also have got to understand that you are also on your side having, you know, lost something. So I must also be responsible, you know, to compensate that. So we meet halfway. So this is where mediation can come into play to help address disputes, especially in the business world. And as I said just now, this is the current initiatives relating to mediation at the international level. So I would like to share the latest United Nations Convention on International Settlement Agreement resulting from mediation, or in short, they call it Singapore Mediation Convention. This particular international convention has been discussed and agreed upon in Singapore back in 2019, just before the pandemic COVID. Yeah, that was in very late 2019. And it has come into force on 12 September last year, 2020. So this particular convention has been signed by 53 states to date, but it has only been ratified by 6 states. That is Belarus, Ecuador, Fiji, Qatar, Saudi Arabia, and Singapore itself. At the ASEAN level, we have Singapore, Malaysia, Brunei Darussalam, and the Philippines who have signed the convention. So this Singapore Mediation Convention provides the signatories, the parties who have agreed a mediated settlement with an efficient mechanism to enforce the terms of the agreement in other jurisdictions. Meaning to say, if we have a mediation agreement, this is an international mediation agreement. When we talk about the businesses, yeah, you have businesses, businesses in Indonesian businessmen having a business in Singapore or in Malaysia, for that matter, or in Philippines, or in Tokyo. Yeah, so using this particular convention, the competent authority in Tokyo can accept the mediated settlement document that we sign on the mediation table to be enforced in Tokyo, rather than going to court. You know, if we have disputes, so Indonesian contractor has got to sue, you know, the other party in the Tokyo court, for instance, and then got judgment, and then enforce that judgment in Tokyo. But under this convention, you need to come to a mediation table, agree to the terms, and then use that document to enforce that in Tokyo, for instance. So that is another way of an outside court process, right? So this particular convention mimic what the New York Convention does for international arbitral awards. So for the arbitration awards, you know, where you also employ an arbitrator to sit in between the disputing parties, and then you have an arbitral award whereby this arbitral award, you can enforce that in the countries that is member of the New York Convention. So they want to do the same thing for a mediation agreement. That's why the Singapore Mediation Convention comes in. Like I said just now, without this Singapore Mediation Convention, without having becoming a member to this convention, the party wanting to enforce the terms of a contract, for instance, must bring an action for the breach of contract and then seek to have the subsequent judgment enforced, potentially in that different jurisdiction. So the process will be longer, to achieve a resolution to your disputes. So having a mediated settlement agreement between the disputing parties would allow the disputes be dispensed with quickly and with less cost, right? Okay, this convention applies to international settlement agreement, that is an agreement between parties in different countries. Yeah, parties are based in different states, or the disputes relate to works performed in a different country from where the parties are based. This can be done as long as the country that you're looking at is a party to the convention, right? Looking at the convention, it has 16 articles. It provides the process of recognition of the international mediated settlement agreement. However, the important thing or in the important issue of the convention is where the convention endorses party autonomy as the primary criteria. Party autonomy, from my understanding, means you give independence, you give 100% trust to the disputing parties to come to terms of what they want to agree on. So the mediator is not going to decide for them. The mediator is not a judge, but the mediator will bring both parties on the same page so that they can agree. And once they agree, they can put down the terms of their agreement in a document. So that particular document can be recognized under the convention, right? So now the issue is that when you go to court, the judges, the lawyers will bring your case or your disputes in accordance with the law concerned. So we are talking here about the rule of law. We believe that each country has got different challenges, different problems of their own. But as long as the courts, as long as the law of the land, as long as the lawmakers or the legal system abide by the rule of law, then you can see a consistent approach towards law. So you can trust the law, you can be confident that your disputes will be handled via the correct way of the court system or something like that. But when you have party autonomy, and we talk about mediation, this is an alternative dispute resolution, you are giving the parties a lot of room to decide. So can they decide on something that is illegal? Can they decide something that involves fraud, for instance? So that is the concern of the people in the law, in the legal system. So I say that this convention must also acknowledge, if you want to have a mediation settlement agreement, it must be subject to the final endorsement and sanction by the court to ensure that the rule of law is not breached. So whatever decision, whatever agreement that you agree on the mediation table must also fulfill or must also be in accordance with the law. You cannot decide or you cannot agree on something that is illegal. All right, so that is at the international level. And I believe, as I said just now, there's only 6 countries that have ratified. That means in their own country, they have the domestic law that will, will abide and will embrace the international convention. Malaysia has not done that, and Philippines also has not done that. Indonesia is not even a party with Thailand. So maybe the reason being maybe of that party autonomy, how are you going to address that? So because this convention is very new, so I believe they'll have more time to improve on the content of the agreement so that mediation will work well, throughout the world, not only domestically. Right, at the national level, we have, I have here 4 states. In Malaysia, we have, to address the mediation, we have COVID-19 Mediation Center, which has been established under the COVID-19 Act 2020, where this mediation center addresses disputes arising from contractual obligations that can't be performed by the parties during the pandemic. So this is the initiative taken by Malaysia. So instead of going to court or having other processes, Malaysia recognized the use of mediation very early on, so to be used to address potential problem between businesses. And in Singapore, the Singapore International Mediation Center has also rolled out the online mediation service. So technology may not be, the answer to everything, but in handling disputes, online mediation service via technology would be very helpful. And in Thailand also, the online court annex mediation via Digital Court 2020 has also allowed the courts across the country to have online mediation. And I believe in Indonesia too, the Supreme Court regulations also provide the basis for online mediation via these rules, right? So at least at the Asian level or the ASEAN level, we are embracing the online mediation. So we recognize the use of mediation to help out the businesses. So the use of e-justice system that includes AI or artificial intelligence and machine learning will widen the scope of online ADR such as mediation. So mediation can be better used to address commercial disputes or intellectual property disputes or disputes involving monetary. And how can this take place? Mediation can take place through virtual conferencing, virtual conferencing processes during COVID-19 pandemic, where you have the parties appearing from the comforts of their home rather than meet face-to-face or traveling to courts. So I would be wondering, if I have to travel to Yogyakarta, the flights that I have to take, and all the way the length of time that will be taken and the cost that I will incur. But having this virtual conference, we can see each other as if we are in the same room, but at a less cost and less time, right? So a comprehensive methodology and prolific use of ADR is the way forward to achieve the desired growth from the alternative dispute mechanism processes such as mediation. So I think mediation is here to stay. And I believe a lot of faculty of law in Indonesia also are looking at the legal clinical education, whereby they have this alternative dispute resolution. Same with Malaysia. We're looking at how best we can include mediation and ADR in our curriculum, so that our students, our law students, our future lawyers would be, have a lot of room to offer to the clients in order to settle their disputes. So I think that's all from me. Thank you very much. So I would also, even though we are still in this pandemic, we can't travel, I would always want to welcome all of you to our School of Law in University Utara Malaysia. So this is the moot court in our university. Thank you. Back to you, Ibu Ani Susanti.
Thank you very much for the great presentations. And ladies and gentlemen, we move to the next presentation, the third panelist in our sessions. It has become the biggest issue during the COVID-19 outbreak that health consumer protections needs a serious attention. Happening in the worldwide, we probably have someone close to us infected by the COVID-19. All needs a medical treatment that takes them as health consumer. The contextual interesting issue is regarding its protections. This topic will be delivered by Dr. Norma Sari SHMH from Universitas Ahmad Dahlan, and Dr. Norma Sari SHMH graduated from Gadjah Mada University for her bachelor, master, and doctoral degree, and she graduated her doctoral degree in 2018. She is also awardee of Australian Indonesia Award in Indonesia for short-term award senior multi-faith woman leader in 2021, and she also Tamu Exchange Japan Foundations in 2019, and she's also a speaker of training TOT in a central board of Nashiatul Asia. And in 2012 to 2016, she was the chairman of the central board of the Nashiatul Asia. And at the moment, Dr. Norma Sari is the Vice Rector of Human Resources in Universitas Ahmad Dahlan. Okay, the floor is yours, Dr. Norma.
Thank you very much, Ibu Dr. Anissa Santi. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Could you hear my voice clearly, Bu Ani?
Yes, quite clear.
Okay, thank you. First of all, I would like to express my gratitude to the committee to give me this great opportunity, having a very fruitful discussion about the COVID-19 pandemic. And finally, I have opportunity to take a seat in between the other prominent professor from various fields of studies. Mom Arroyo, really great to see here with you. Mom Arroyo, oh, you are there. Okay, Ibu Ani, I'm the last speaker of quite long panel session. So I found that some participants are not quite happy. Yeah, because maybe a bit sleepy or something like a headache or something like Zoom fatigue or another symptom. So I'm going to start my presentation by asking for all the participants here to have like it's like a game to start from my presentation entitled Health Customer Protection During COVID-19 Pandemic. Kiki, please open the game from menti.com. Actually, it's not a full game, but I'd like to start to discuss with all of you about the health consumer protection. Would you please open www.menti.com and please to enter the code 4999045. You please, all of you, to participate. Ibu Ani, are you trying to participate on this game? And type a word about health consumer protection. Yes, type just one word about the health consumer protection. The top main word. The top main word. Okay, we are waiting for the result of the participant. We have 188 participants, right? Patient. Okay. Health consumer is a patient. next one, the other participant. It's okay, Bu Ani, because it is late afternoon. I'm afraid that I'm going to push.
Everyone is still thinking the best answer.
That's okay.
Maybe the participant is thinking of having a special door prize for answering, for responding the question.
Yes. Let the committee to think about. Question. Word. Just a word or a related word about health consumer protection. Oh, medicine. J. Kian, Jaminan Kesehatan Nasional, BPJS. Update sana ya. I don't know, we have a delay of the screen. Jam Kesda. Yes. JKN, BPJS, Jam Kesda, Medicine. The Constitutional of Republik Indonesia, 1945, Undang-Undang Dasar 1945. Administration barrier, yes, indeed. When we talk about health consumer protection, we challenge or we are facing a problem with the administration barrier. Is Kartu Indonesia Sehat? Okay. You're waiting for other participant. Medicine, nurse, yes. Nurse. Yes. What's the other? Ethic. Yep. Ethical problem will be raised during the health consumer protection issue. Doctor or physician, yes. Security, yes. We are in the situation of unsecure. Oh, something was make a note, trying to make a note. Service, yes. Security, service, doctor, medical doctor, ethic, the other words, media, yes, obat or medicine, malpractice. Vaccine, yes. And what else? Human rights, yes. Standard or standard of operating procedure. Malpractice. Coma person, yes. Mental, mentally, health, mental. Is it okay, Bu Ani?
Yeah, it's still about 15 minutes to go.
Okay. Expensive, oh, that's great. A participant wrote about expensive. COVID, yes, we are going to discuss about the health consumer protection during COVID-19 pandemic. Health protocol, yep. Mantri, oh, mantri. Pancasila, oh yeah, 5 sila. Indonesian ideology. Okay. Okay, Mas Kiki. Let me stop. Thank you very much for all the participants of this international conference to participate on this kind of games. Not really a full game actually, but I want to start this discussion by discuss with the main word on the participant. Next slide, please. Oh, it takes time, Bu. I don't know. What's the problem?
It's like a delay.
Delay, yeah.
Yeah, it's like a delay. So for the, yes. Next.
Yes. The COVID-19 pandemic has a profound impact of various dimensions of life. All the speaker has said about this. So we are going to talk about the health consumer protection. Health consumer are people who use health services, as well as their family and careers. This includes people who have used a health service in the past or who could potentially use in the service in the future. So we underline the word of health services. But including of the health services, the consumer is also someone who consume the medical devices. And we know that the restriction imposed by the government have an impact on the relationship between the business actors and consumers, including the health consumer. I'm going to give illustration with my pen here and my pencil. The relationship between the consumer and the business actor actually in imbalance bargaining position. Next. Oh, always delayed. Bu Ani, could you please to ask somebody to help me?
Okay. Maybe the operator, yeah, we will switch the operator for some moment.
For the co-host maybe?
Yes. Okay. Waiting for...
This is technological barrier we have to face.
Yeah.
It's okay. Hello, Mom Arroyo.
Hello. Hi again. Good afternoon.
Good afternoon.
Yeah. It's what time is it in the Philippines?
Sorry for
it's 3:16. It is 3:16 in the afternoon. No, here in the Philippines. We are ahead of 1 hour.
1 hour.
Yeah. So it must be the internet. That's the problem.
The question is about how to protect health consumers during the COVID-19 pandemic in Indonesia, and how do the state and NGOs action to protect the consumer? Next. Next.
Maybe for the operator, not in a full screen, just in a...
Okay.
Oh, yeah. Yeah. Make it not in a full screen.
The full screen will...
Yeah, okay. This maybe better.
Okay. Now, let me talk about the right of health, because it is very important for us to start this discussion by the right to health. According to the World Health Organization, health is a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. The right to health is a basic right, different from the right to be healthy. The right to health is inclusive. We often associate the right to health with access to medical care and the construction of hospital. This is correct, but the right to health extends further. It includes a wide range of factors that can help us lead a healthy life. So the right to health is not the same as the right to be healthy. The right to health have a wider meaning rather than the right to be healthy. Next. Please, agak cepat dikit, Ki. Bu Ani, could you please someone to assist?
Yeah, it's already in the next slide, Ibu Norma.
No, Bu Ani, we are going to move to another slide.
Oh, okay. Slide 6, please.
Who is the consumer? Each individual user goods and or services available in society for the benefit of themselves, family members, and other people and other living creatures, and which are not for trading. The term of which are not for trading refers to the end consumer or end user. The right to health is a basic right for consumer. Even, sorry, previous slide, please.
Slide 6.
Previous.
Slide 6.
Previous slide, please.
Slide 5.
Kamu atau siapa yang operate? No. Please change to another. Please log out. Bu, please to choose another operator, please, Bu.
Oh, okay. Will be the wait for a second. Let me.
Okay. I'm going to continue that about the who is consumer. The right to health is a basic right for consumer. Consumer rights are the right to confer security and safety in consuming goods and or services. So safety is related to the right to health. As mentioned in Article 4, Consumer Protection Act. But the condition of health consumer are vulnerable. As I mentioned before, that in nature, the bargaining position between the consumer and the business actor are in imbalance bargaining position. Or I would like to say that the consumer is a very, very weak bargaining position in front of the business actor. So the vulnerability of health consumer caused by so many problems. The first is vulnerable due to the exposure of the COVID-19 virus. As we know, in the beginning of the pandemic, if someone confirmed as a positive COVID-19, so the society will give them different treatment like stigmatization or avoid them or avoid all the families, something difficult to face for the victim of the COVID-19 viruses. But now Indonesia is not only facing the new model of Delta virus, but we also facing the Delta plus virus. So it will be a greater problem if we cannot adjust with this situation. As I mentioned before, that the vulnerability due to the exposure of the COVID-19 virus, when the society are not aware that the stigma will impact the worst situation of the consumer, so we need to educate the society. Don't blame the victim of the COVID-19 virus and the other ones. And the second one is the health consumer vulnerable due to the restriction. Previous slide, Bu. Previous slide, please. Previous slide, Bu. Ibu Ani, could you hear me? Previous slide, please.
You want to have in slide 6 or okay.
Yes, this one.
Okay.
Vulnerable due to the restriction. The implementation of the social distancing, large scale of social restriction, and community activities restriction enforcement, on the one hand, is an effort to prioritize the scale of protection. But anyhow, the protection as the result, consumers are not free to access the health equipment and health services. It also in trade. Activities are carried out online, which makes potential consumer receive unexpected good. In example, a few days ago, the experience of a celebrity doctor who got the fake vitamin through the marketplace. In service, consumer of health service must transform to e-health services due to the restriction. This is a potential condition in the future that we are growing up with the telemedicine. But anyhow, this telemedicine still have so many forthcoming to be settled first. The other issue is about the medical data, because the digitizing hospital data and other healthcare institutions make the health data that was previously stored in folders now become digital and stored on servers that do not have to be located in health facilities. Hospitals are now installing a new system that allows doctors to view and update patients' medical record via computer in the practice room. Because it is sensitive personal data, its contents can be misused by various parties. The third one is about the vulnerable due to the business actor violation. The Consumer Protection Act of the Republic Indonesia, which came into force in 2000, has provided clear guidelines regarding obligation and prohibition for business actors. However, we don't deny that naturally there are always business actors who pursuing profit as much as possible, doing anything without considering consumers' interests. As we know that in one hand, business actor is also consumer, but once they are entitled himself as a business actor, they forget the consumer interest. Here, some cases experienced by consumers during the pandemic. The first one, the shortage of personal protective equipment. In the early stage of outbreak, the shortage of personal protective equipment became the first issue to handle. The Indonesian Consumer Foundation once criticized the government for not getting involved in the increase of the price of the masks. So about the mask, about the hand sanitizer and the gloves, there are kind of personal protective equipment which are shortage in the early stage of the pandemic. The second one is about the scarcity of drug and supplement. Several pharmaceuticals industries have seen a surge in demand for multivitamins products during the coronavirus pandemic. There is an increase in demand of more than 100%. There are also up to 3 times. And the third problem is the oxygen shortage. The 3 group of holders of COVID-19 drugs and oxygen vendors were arrested in connection with the operation to monitor the availability and prices of medical devices during the pandemic. We lost some people due to the oxygen shortage. That is the worst situation even ever happened in Yogyakarta. And the fourth one is the vulnerable due to the psychological pressure. Psychological pressure is very visible in the consumption pattern of consumers who take the panic buying action. In the early days of the pandemic, consumers store various groceries at home, triggered by the possibility of long lockdown. The intensity of panic buying rose again when there was a new wave of confirmed cases, especially several products for increasing immunity, such as dairy products, herbal products, or multivitamins. Panic buying, considered as a situation in which many people suddenly buy as much as possible everything because they are worried about something that maybe could be happen in the future. So, in fact, the media has a vital role in controlling panic buying. Promoting family affection and encouraging generosity can reduce this from the public side. Next.
You have 2 minutes left, Ibu Norma.
Yep. Yes, next. I only have 2 minutes left. Next slide, please. Okay, consumer health protection during the pandemic COVID-19. The first one is consumer health service facilities. We are talking about the PCR tariff issue, the telemedicine issue as well. And then the medical device consumer. We are talking about the changing categories of essential goods and or basic commodities. So on the conventional and 1995 masks being essential product after the changing of the regulation. And the third one is about the vaccine consumer. Vaccine consumer also have the basic right. Who please not jump to conclusion first. We are not jumping to the conclusion, Bu.
Okay. This slide?
No.
Before this?
No.
After this? Do you want to?
No. Previous. Before this, Bu.
Still this one?
Before this, Bu. One more.
Before this.
No, Bu. Previous
Next.
slide, please.
Previous or later?
Yes.
Okay.
Next. No. 8.
Okay. 8.
Okay. Okay. The state presence. Naturally, in the bargaining position of consumer business actor relationship is imbalanced, so the state must be present to save the vulnerable consumer who suffer more during this pandemic, ensuring to promote, protect, and enforce the right of consumer, fulfilling the basic consumer need, especially in the health consumer during the pandemic, and guaranteeing the fulfillment of the right to health and safety for workers in the health sector, and addressing the needs of the marginalized groups. So I'm talking in a very, very wide topic. Next.
slide 9. This is slide 9.
What's wrong ya, Bu? Okay, community
This
health
is slide
self-help, a portrait of Indonesian Muhammadiyah volunteerism. Okay, I'm going to talk about the Muhammadiyah work here because we found that the effort made by Muhammadiyah directly protect the health consumer who are experiencing a difficult situation during the pandemic. Their action not exclusively only for Muhammadiyah, but also for the Indonesian people. Protection in the context of fulfilling the basic right of the health consumer illustrate the role model of community empowerment for consumer health protection during pandemic. And here, the statistic number on the diagram. Next.
The diagram.
The picture.
Yes. This is the only 2 slide left.
Yes.
Okay. Seems that there is a delay from the screen to your screen, Bu Norma. It's already slide 10.
And the next slide.
Yeah.
Okay. We are going to jump into conclusion. Jump into conclusion.
Yes, conclusions. It's conclusion already, Bu Norma. Can you? Okay.
Okay. Health consumer protection during the COVID-19 pandemic in Indonesia is based on international legal instrument and national laws. The main and general national legal instruments like Health Act, Hospital Act, Consumer Protection Act, and Trade Act. And the state should always be present in every single time of handling COVID-19 to ensure that the health consumers are no further disadvantaged before a business actor, conducting regularly intervention, ensuring implementation and advocacy since the production, distribution, and consumption lines must be carried out to guarantee the balanced bargaining position and the fulfillment of the rights. Several regulations at the level below of the law that regulates telemedicine, control of basic goods, vaccination, and marginalized group demonstrate the government's effort to protect consumers comprehensively. But anyhow, all these actions are not enough because the problem we have to face are ultra complex. Muhammadiyah through Muhammadiyah COVID-19 Command Center is a role model of voluntarily work, community-based self-resilience in health consumer protection. Thank you, Ibu Ani.
Thank you very much, Ibu Norma, for the great presentation. And ladies and gentlemen, this is the end of the panelist presentations, and we would like to have question and answer sessions. We have about 15 minutes as the time is quite limited. There are some questions I found here in the chat list. Okay, it's already 10 questions coming in. I would like to random the questions. Probably if we have time, we will read all the questions, but as our time is limited, then I would like to have a random picking. Okay, first question from Septi Nurul Alvina Husdi. Participants, I would like to read the questions. This increasing pandemic case can lead to an economic crisis, which can also have an impact on education because it must be carried out virtually not only in Indonesia, but also in several countries in the world, where students experience difficulties in accessing learning due to several factors such as internet connection problem and etc. What is your opinion regarding this? Wouldn't that hinder the development of education? And what are the efforts that the government should take to overcome this problem? Okay, this might be the questions to Professor Arroyo with the topic of education probably, but we would like to welcome all the panelists to respond. We can start from Professor Arroyo.
Okay, so regarding the problem or the issue the challenge, how do we call this? We look at it as a setback, of both the government and the school. And who is to suffer? The students, the learners. Now, this is the time when the government should come in to rescue the schools. Well, in our country, the government has already stepped up the policy, as the aid, the fees to the school, in delivery of learning. Much as we do distance learning, online learning, most of the schools are still the schools distribute these modules, and the distribution of these modules. At least they help in the distribution and retrieval of these modules. But in private institutions, like in our university, we are 100% online. And the support comes from the administration. Members are supported by free internet. So it is now the option of the teachers whether they work from school or they work from home. So if they do not have strong connectivity to the internet, they choose to come to work here in school. Because in school, we are assured of internet connectivity. Even with power interruption, sometimes we still can conduct our lessons. So what is the government doing to private institutions? Well, I haven't heard of any subsidy coming from the government, given to private institutions when it comes to connection. That is problem. So those in the this problem. Provincial university, although we are in a city, it is still in the province. So you can imagine how difficult it is for us to do this. But then we are doing all our best. So we do the synchronous, the asynchronous way. We have backup strategies. We have backup plans. So we use almost all the letters of the alphabet. We have plan A, plan B, plan C, and so forth. That if plan A doesn't work, we have a fallback. But, well, I think it is a universal problem, this internet connection. Because of the number of users now, and stop, these users getting connected to the internet. That is the. So it is now the provider. They should also improve, increase their capabilities, in order to meet the demands of the learning, the consumers, the learning communities.
Thank you, Professor Arroyo. We also welcome Dr. Rohana to respond to questions on the educational issues. Probably you can share the situations in Malaysia. Dr. Rohana?
Thank you, Ibu Ani. I think I agree with what Professor Arroyo has said just now. But as for Malaysia, as I said in my presentation, the schools are not open. It opened sometime few weeks early in the year, but closed up again because of the lockdown. But there have been a call for the government to have what we call TV pendidikan or education TV. Because when I was small, we used to have English on TV every Thursday, meaning we learn English on our television. So there will be a segment on education every Thursday from 8 to 9. So we used to have that when I was small. So so there was a call for this kind because they have a lot of content. So I think if you can't reach out the people via the internet, so you can have education through television, because I think everybody, I mean, most people, or even in the villages, they have television where you can reach out to the people. So there has been call for that, and I'm not sure how far Malaysia has actually operate on that manner. But I think the Ministry of Education is doing all they can, you know, to have that. And we have also having teachers sending out schoolwork via the Telegram or WhatsApp messages, and asking the students to come, or even the parents to bring in the work to school on weekly basis. So they do it at home, and then they send to school for the teachers to mark. So these are the things that the schools have got to take the initiatives. But at the university level, early in the year, when the number of cases were a bit down, we allow the students to come in for certain courses which need to have the hands-on experience. Like in law, we have a student coming in to do their advocacy and mooting sessions in the moot court, for instance. And we need to have the face-to-face engagement. So we allow that with very tight SOP, standard operating procedure. So all this, adhering to a lot of rules and regulation. But we cannot have a lot of students into the university because of the SOP. So we have to pick and choose. But there are also students who really cannot or do not have any facility at home in their remote villages. These students we allow to come into the university, because if they stay at home, they cannot follow the online classes. So we allow these type of students to come back to the campus to do the online courses at the university. So I think all the universities in Malaysia is doing that, because that is the directive of the Ministry of Higher Education, to allow students who have problem to come back, but not all of them. Yeah. So we engage with the student all the time, asking them if they have any problem. And now we see that problems that surface is not only because of data or internet lagging. Students are also facing financial problem. You know, families who were having no work and stuff like that. So the students have got to help the family. So when they go out to work to help, then they are not learning. So these are financial problems that we are looking students, especially at the university level, because they are the older siblings, right? So they have to help the family instead of the younger ones. So these are the issues that we have to be compassionate about. So I think, it's a long run for all of us. This is a new thing. We have to, I don't know, we have just to pray hard that everybody will understand and observe the SOP, so that the spread of the virus can be lessened, and we all can, maybe not back to normal, but at least we can have some semblance of order. Can go back to school, can go back to work, can go to the supermarket to buy stuff, can see other people going back to work to earn their living. That's my response, Ibu Ani. Thank you.
Thank you very much, Dr. Rohana. We also welcome one participants to ask questions directly here. You can switch on your microphone and ask questions, or having some response, or maybe you, for those who have already listed or know the questions, you can also directly ask. Any of you want to respond, or if no, I would like to pick randomly again from the questions. This is the last questions. Yeah. Okay. I would like to take the last one, the last questions. Yeah. From Lutfia Amanda, participants, I want to ask the implementations of the lockdown add to the misery of the people in finding money. Will there be rules about empowering the welfare of the community, especially the underprivileged during the pandemic? Maybe Ibu Norma will respond the questions about how we consider the community welfare during the pandemic. Ibu Norma?
Okay. Sorry.
Yes. There is a questions from the participants about the effect or the impact of the lockdown to the people welfare, to the economy sector. I guess the questions would like to go there. What will there be a rules about empowering the welfare of the community?
Okay, thank you. I get the point. This is a global pandemic. So we have to focus on the situation that this is not some country's problem, but this is a global pandemic. So when we face this situation in our country, so the other country also have similar situation. We couldn't settle this problem individually or each country, but we have to bring together, as Mom Aryo previously said, that we have to share. Facing this problem. This is the common goal of us, that the pandemic or this outbreak will be over. So every country facing this situation to prioritize which one must be taking in first, the economic situation or the safety situation. And most of the countries prefer to choose the safety first rather than the economic situation. There is no ideal situation during this outbreak. So when we choose one for the prioritizing of the human life, in the other hand, we have to take the disadvantage of the economic condition. We on my paper, I offer like community empowerment, because I think up to now for the whole country like Indonesia, which is very diverse country with the large location with the huge population, a country maybe each country has a willingness and ability, but I'm not sure about the ability. So we offer to encourage the people, to empower the community to get the self-resilience. Because if we let the government, let's say the government have to handle all these responsibilities, I think it's not fair, because the situation even being worse when we only take no action. So the economic empowerment, like economic resilience, need to be addressed to face this situation. The other rising problem here is about why Indonesia took so long to recover from this outbreak. It is caused by the huge number of population, the availability of vaccine, and the characteristic of Indonesia with the archipelagic countries. So to consolidate the people in one time, in one vaccination action, it's not easy. So when we talk about the Indonesia as archipelagic countries, we must rethinking about taking the benefit of this situation. We have to solve it in each region to solve this problem. And we also think or consider another region. So we don't take egoism in this situation, but sharing together, as Mom Oreo said, is the best way to take the resilience of the situation. Thank you, Bu.
Thank you very much. The response from Bu Nurma marks the end of the question and answer sessions because we have very limited time, ladies and gentlemen. And before we close the sessions, the committee would like to appreciate a token of appreciation for all the panelists this afternoon. First of all, we would like to give the certificate to Professor Dr. Estrella Arroyo from University of St. Anthony, Philippines. This is the certificate. Kindly accept the certificate for you. Thank you for the valuable sharing. And the next, we would like to give the certificate to Dr. Rohana Abdul Rahman from University Utara Malaysia. So many thanks and kindly accept the certificate for your great presentations and discussion. And the last, we would like to hand a certificate to Dr. Normasari SHMH from Universitas Ahmad Dahlan. Thank you for the valuable presentations. Ladies and gentlemen, this is the end of the panel sessions this afternoon. Thank you very much for attending these sessions. Stay safe and stay healthy. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Sorry for the technical barriers. Bu Ani.
Yeah, there was delay, Bu Nurma, from the screen is already coming in, but maybe in other computer it's not already appear. Thank you, Ma'am Arroyo, Dr. Rohana.
You're welcome.
You're most welcome. Thank you very much for inviting.
Nice to see you again, Dr. Rohana.
Hi, Dr. Norma.
Yes. Hope this pandemic will be over soon.
Inshallah. Take care.
I give the time to the Master of Ceremony. Back to the Master of Ceremony. Thank you.
Okay. Ladies and gentlemen, thus we have come to our last agenda for the first day of the conference. We ask authors, CEO authors, presenters, and participants of this international conference for the second day of tomorrow, Tuesday, August 5th, 2021. Please to make preparation and register at 7:30 until 8:30 a.m. The parallel session will be held at 8:30 a.m.
Once again, we thank you for your attention and cooperation, so that the first and the second panel session can run well and smoothly. To close today's agenda, let's say Hamdalah together.
Alhamdulillah Rabbil Alamin.
Hopefully, we all get benefits and knowledge from our agenda today. I'm Sakti Oktasari.
And I'm Fadil Muhammad Ikwansyah.
And the entire committee on duty apologize profusely if there is word and behavior that are not pleasing to the heart and of the guests and participant international conference. Thank you for the time and opportunity. See you in the next morning.
Wassalamualaikum warahmatullahi wabarakatuh. Good afternoon and greeting to all of us. And then the last performance, acoustic music from Mabes Music Project. We welcome.
UAD. UAD.
Cek.
UAD. 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 UAD.
rembutan. Semuanya. Oh, oh, cinta akan ku berikan bagi hatimu yang damai. Cintaku gelora asmara seindah membayung senja. Tiada ada yang kuasa melebihi indahnya nikmat bercinta. Betapa nikmatnya dicumbu asmara bagai embun pagi yang menyentuh rerumputan. Oh, oh, cinta akan ku berikan bagi hatimu yang damai. Cintaku gelora asmara seindah membayung senja. Tiada ada yang kuasa melebihi indahnya nikmat bercinta. Oh, oh, cinta akan ku berikan bagi hatimu yang damai. Cintaku gelora asmara seindah membayung senja. Tiada ada yang kuasa melebihi indahnya nikmat bercinta. Cinta akan ku berikan bagi hatimu yang damai. Cintaku gelora asmara seindah membayung senja. Tiada ada yang kuasa melebihi indahnya nikmat bercinta. Indahnya nikmat bercinta. Indahnya nikmat bercinta. Okay, so the song was titled Cintaku by Krisye. Okay, the next last song from us at the same time closes our meeting this afternoon, and see you again tomorrow morning. Ladies and gentlemen, considering the COVID-19 pandemic, the number of positive people in increasing, I hope that all of us here continue to abide health protocols by keeping our distance, washing our hands, and wearing masks. Okay, the next song. Sejak jumpa serba salah